Good morning, honorable members. Welcome back this morning. If we can take our seats, then we can begin the day. Thank you, everyone. Good morning again, and welcome to our last day. It's a beautiful sunny day in Joburg. It's been raining for a long time, and we finally see some sun. So I would like to propose that we try to finish up by lunchtime today. I don't know if members are in agreement with that, but I think, thank you. You can only deal with prisons so long before you get thoroughly depressed. So before we do that, what I would want to propose as our agenda for today is Professor Lucas Munting, based at the Dalai Lama Institute at the University of the Western Cape, will take us in great detail through everything you need to know about prison oversight. And this would be your opportunity this morning to ask the questions you need to know to be able to explain things back home in your parliaments. Feel free to ask about anything linked to prison oversight, obviously not linked to anything else. I don't know how far his expertise go, but let's see. So what we'll do is Professor Lucas Munting will go through his entire presentation. Please take notes as questions come up, and then after he's finished, we will then go through a few rounds of questions and answers. We will then break for tea. I'm hoping by the time we're done with tea, we could probably come back here, have a little bit more of a discussion, because there's a lot of issues that are going to come up. We're going to end the day with a presentation from the Nelson Mandela Foundation and then closing remarks from the SG. So I think this is the last call this morning. Let's put in the energy, get to grips with the technical issues, and just enjoy the process. So I'm calling up Professor Munting, who will give us his presentation. Thanks, everyone.
Okay, good morning. I was listening to the deliberations over the preceding 2 days and made some notes on my planned presentation, and so I'm trying to get to a bit of a pulling everything together, and I hope it forms a basis for some useful discussions so that we can take this process forward. But I want to start with a quote from the French sociologist Michel Foucault, who is more or less the father of prison studies, at least in our part of the world. And he observes that we are aware of all the inconveniences of prison, and that it is dangerous often think that is where we are, is that we know, we're so aware of the problems of imprisonment, and we've seen the videos over the last 2 days, and so many of us have visited prisons, and somehow we cannot see what to replace it. And so if we feel a bit frustrated and despondent, I think it's normal at this stage. But let's see if we can bring some improvements through more effective oversight. So the draft framework was circulated. I don't know how many people had a chance to page through it. But this discussion this morning is really an opportunity to define the scope of the model law. And it's pretty much up to this gathering to say it should take this direction and include that and exclude this. But that is how the process works. I think it's important to note from the outset that the focus is on prison. That is the brief that we received. It's a model law on prison oversight. There are many other places where people are deprived of their liberty, and those places are covered under the optional protocol to the Convention Against Torture. Our focus here is on prisons. And so I've listed a few key concepts that I think we just need to reflect on a little bit. So the first one is, what is a prison? And it's deceptively difficult to define. But here is an attempt that a prison means a place where people are detained following an order by a court, and that such a place of detention is gazetted or proclaimed as such, and for which a line ministry takes responsibility. The fact that police stations are at times used to detain awaiting trial prisoners does not make that police station a prison, as it has not been proclaimed or gazetted as such. And I think it's important to get these legal definitions in place in whatever shape our model law takes. Monitoring, and I'm listing monitoring because monitoring is distinguished from inspections and from investigation. So monitoring, if we're talking about oversight, is a process over time of regular examination of all aspects of detention. And the examination can involve all or certain categories. So you may visit a prison and say, today I'm only looking at the women in this facility, or I'm only looking at healthcare issues in this facility, or we're doing a comprehensive visit. And all aspects of detention are interdependent and must be examined in relation to each other. And that will also, monitoring also includes reporting. So following a monitoring visit, there must be some recording of what information was collected, be that in writing or audio recording, and something must be done with that information. It must go somewhere. Monitoring has no impact if you keep the information for yourself. An inspection, that's the act of looking at something carefully, or an official visit to a building or an organization to check that everything is correct and legal. And an inspection can be announced or unannounced. And it may also be a follow-up inspection on particular issues. But inspection is then, monitoring is a series of events over time at a particular regularity. And an inspection is looking at something now. What is going on here now? An investigation is a particular type of inspection, if one can call it that. It is the act or process of examining a crime, a problem, or a statement in order to discover the truth. And the UN Convention Against Torture states, in respect of the obligation to investigate, whenever there are reasonable grounds to believe that torture and or cruel, inhuman, or degrading treatment has taken place, the state has a duty to ensure that this is promptly investigated by competent authorities and in an impartial manner. So in the context that we are working here, prisons, investigations have a particular meaning. The definition of torture is also important, and we've heard over the last 2 days that all except 2 SADC members have ratified the Convention Against Torture. Article 1 of the convention defines torture, and I'm not going to go, I'll just summarize it here. There are essentially 4 characteristics of that definition, and the first is that the actions must result in severe mental and or physical suffering. The second requirement is that it must be intentional. So there must be a purpose. It's not a closed list of purposes. It can be any purpose. And so torture cannot be accidental. There must be an intention, whether that is to extract information or whether to discriminate or punish somebody, but there must be some intention. It must be committed by a state official or at the behest or acquiescence of a state official. So even if it's, let's say, done by a private company who runs a prison, as is the case in South Africa, the department, or it would still meet the requirements of the definition of torture because the private company is contracted by the state to run the service. And then lastly, it excludes suffering resulting from lawful actions. So if a police officer is executing an arrest, the suspect is resisting, but he maintains a minimum use of force, but unfortunately the suspect breaks an arm, there is suffering, it may be severe, but the policeman can argue, I was executing a lawful arrest, and he has the evidence to back it up. The definition in Article 1 must, of course, be read with the requirements in Article 16 that deals with the prevention of cruel, inhuman, and degrading treatment that do not meet the requirements of torture. So these 2 work hand in hand, and for our work in prisons and oversight, they are really important. The recidivism rate, I thought I'll sneak this in here because there was a question or a comment yesterday about recidivism rates, and somebody, I think was the South African representative, who claimed that the recidivism rate is 90%. I can assure you that we do not know what the recidivism rate is. It is extremely difficult to do reliable research on it. And even if you do get a figure at the end, what does it mean? What do you do with that figure? So to make a claim that 3/4 of people, or the recidivism rate is 70% or 90%, really doesn't help us in understanding what trends are. There's research from other parts of the world that have tracked birth cohorts for almost 50 years now. Offending patterns are, and they can distinguish types of offending patterns. Young people, young men typically tend to offend at a high frequency early on in their teens, but then stop. But there are other types of offenders who continue offending throughout their life at a high frequency. There are other types of offenders who continue offending throughout their life at a much lower frequency. So it's a really dangerous figure to say the recidivism rate is 90% because it doesn't distinguish between all these different categories of offenders. So that's my sidetrack. If we then move on to what is the aims of a position paper, and that is why we are here this morning, is to decide on that framework for a position paper. And so the first issue a position paper does, it defines the issues hopefully clearly. So it identifies the problems or the gaps in existing laws or policies or governance structures. it seeks to establish a justified position. It articulates a perspective of the organization, in this case SADC, Parliamentary Forum, and it presents legal, empirical, and normative arguments supporting a proposed position. So we are working on a policy paper that articulates our position in respect of a model law on prison oversight for the region. It provides evidence and comparative analysis. So what you'll see from the concept note and from the existing draft of the framework is there's reflections on empirical data, a bit of statistics, some reflections on what happens in other jurisdictions, some case law, and that goes all into informing our position. Then it needs to outline policy and legal recommendations. So then it comes to a position where it must say, okay, we want to do it this way, and this is what we are proposing. So typically it would include principles and guidelines on what should underpin the model law. Importantly, a position paper is an important advocacy and negotiation tool. So you would go back to your various countries and you'll have a position paper, and you'll need to interact with other members of parliament and say, we need support for this. One may also reflect at other fora in SADC. The Honorable Jeffrey mentioned the Forum for Ministers of Justice, so that would be a place for advocacy and negotiations on how to take such a model law forward. And then, of course, it facilitates consensus building. It will obviously strengthen this position paper if there's agreement from this forum that this is how we want to take it forward. So, with our concepts under the belt, we have said what our position paper should ideally achieve. We can, and many people mentioned this data from the framework document and from the concept paper, but we know there are some 400,000 people in prisons in SADC, and half of them are sitting in two countries, South Africa and the DRC. We know that roughly 3% are women, but there are indications that that proportion is slightly growing over the years. It's a function of a variety of things, but drug law enforcement is one of those drivers that have been identified in other parts of the world. On average, 35% of prison populations are awaiting trial. My own view is that this is a very high figure. One needs to look at how we can bring it down. The average imprisonment rate is 150,000 per 100,000 of the population. 150 per 100,000 of the population, with a median slightly lower at 119 per 100,000 of the population. So compared to other parts of the world, Africa, or at least SADC, has a fairly low imprisonment rate, but there are a couple of outliers like South Africa that is close to 300 per 100,000 of the population. We recently did a study on women in prison in South Africa and Mozambique, looking particularly at the Bangkok rules that deals with women in prison. And the message came over and over and over that prisons were designed for men with male security concerns as the priority, and women find themselves marginalized in terms of their status and needs in male designed and dominated prisons, and also in the management of prisons. It's men's concerns that are prioritized. So that's something that one can perhaps take forward. I've been doing research in this field for a good 20 years now, and empirical research in Africa about imprisonment is rare. It's difficult to find. And it places a limitation on the extent to which we are able to make evidence-based policy recommendations and evidence-based law reform. But that is the situation, and I think it's important to acknowledge that limitation. So there are a number of legal and policy justifications that we need to be aware of going forward. We've mentioned the status of ratification of OPCAT in the region. An important requirement of the convention is that states must report every 4 years on measures taken to implement the convention. And so those state reports or country reports are really important tools to reflect on as members of parliament or academic research community, is to see what the state has done to implement the obligations under the convention, but also to implement the concluding remarks from the committee on the previous report. So there's a lot of useful information there. In UNCAT, and one of the other speakers have mentioned is that the prohibition of torture carries under international law the status of a peremptory norm, which means that there can never be any excuse for it. And that there are some important decisions, especially in the US, that found that phrased it as follows, that the torturer has become like the slave trader and the pirate before him, an enemy of all mankind, which means we must take that prohibition of torture extremely seriously, and that we must give it a very prominent place in model legislation. The African Commission on Human and People's Rights have made a number of recommendations and published instruments regarding imprisonment. There's general comment number 3, and if I recall correctly, let's get the correct reference here. It deals with conditions of detention. For example, when the state deprives an individual of liberty, its control of the situation yields a heightened level of responsibility to protect that individual's rights. So very clear message there from the African Commission. There are also the ACHPR guidelines on conditions of arrest, police custody, and pretrial detention in Africa, also known as the Luanda guidelines. And then there are the substantially older Robben Island guidelines on the prevention of torture. So there is a substantial body of guidance, even in soft law instruments from the African rights framework to assist us. So what are the needs for a model? Why do we need this? And it's a question I think we need to take seriously. I think that the Parliamentary Forum has identified this as a very strong step in the right direction. So the first issue is that there are gaps in the legal frameworks. What we saw after 1990 is that many African states have gone through a process of constitutional reform. And much appreciated, but that constitutional reform did not necessarily result in the enabling legislation being reformed. So and that's why we see, and I won't name the country, but a new constitution dated, I think, 2010, if I remember correctly, but until very recently, the prison legislation was dated 1938. So it's those type of things that one needs to bring forward. There are different mandates and powers that are given to judges, to magistrates, to members of parliament, and to civil society organizations. So there are these disparities. Sometimes, especially with regards to members of parliament, their powers to visit places of detention and prison are very clearly articulated in the Constitution, and that helps a lot. But sometimes it's assumed that they can collect information. It's sort of broad phrasing, and they use that power. But it also means that if it's vague, there can be pushback on it if the situation changes. There may also be different understandings of what is oversight. I think on the one hand, the most obvious is prison-based monitoring. And that is, you see in the videos, is where Victor visits a prison and they ask questions. And prison-based monitoring is really important because it looks at the conditions of detention, it looks how early release mechanisms are managed, it looks at how human rights are protected in that particular facility, it looks at health issues, it looks at how the facility is managed and what the status of the administration is, and it may also look at what efforts are being made to prepare people for release. But that is one aspect of oversight. The other is the more systemic perspective. And this is where parliaments are really important. And I must emphasize that these two perspectives must work in tandem. And because parliaments have generally the duty to hold the executive to account, they can request information. There are various reports that must be submitted to Parliament. There are reports from national human rights institutes that must be submitted to Parliament. There is financial information. So there's a lot of information that comes to parliaments that can be utilized to support prison oversight. At present, there are, and inconsistent is perhaps not the right word, but there's variety in oversight mechanisms. There's no uniform standard or mechanism based on a common set of principles. And this is a result of historical developments. Countries developed under different legal systems, different historical traditions, different colonial administrations. So this is what we have at the moment, and we're trying to build some commonality and consensus in this diversity. Throughout the literature on oversight, whether it's prisons or any other form of oversight, this is a constant refrain that oversight must be independent. And the issues, I think, in respect of prisons, very neatly summarized in the Sonke decision recently from the South African Constitutional Court, where the court opined that to effectively scrutinize correctional centers and remand detention facilities, an oversight body should maintain an arm's length relationship with the department, in this case, the Department of Correctional Services. It should be sufficiently insulated from undue influence or capture, a word that's very prominent in South African politics, by the very departmental officials whose conduct it is charged with monitoring. In addition, it must gain the confidence and trust of inmates. Inmates' confidence in the work done by a correctional center oversight body will depend largely on the extent to which that body is perceived as being independent. And this is really important. It must not only be independent on paper, it must be perceived by prisoners to be independent. And the reason for this is that prisoners or inmates are entirely dependent on the administration for meeting their needs. If they're hungry, they can't leave the prison and go buy food. Or if they are sick, they can't leave the prison and go to a doctor. No, they're dependent on the administration. And that high level of dependency can easily be exploited, misused, and manipulated. And that has obvious rights implications. So if we then look at the mandate and powers of an oversight structure, there's a researcher, Ditch, who formulated a number of principles. And as we noted already, they must be independent of the correctional agency. They must conduct regular routine inspections that may be announced or unannounced. Monitors must have a golden key. In other words, they must have access to all places, people, and records in a facility. Nothing must be hidden. They must be adequately resourced with sufficient staffing, office space, and funding, and they must control their own budget. They must have the power and the duty to report their findings and recommendations to fulfill the objective of transparency. Your particular principle, for example, the International Committee of the Red Cross, they visit and they've got access to places of prisons and other places of detention, but they conduct their visits confidentially. They never disclose what their findings or recommendations were to the public. It's something that they discuss with the state party, and they see what improvements they can bring. And so the International Committee of the Red Cross has wide access to places of detention that other agencies will never have, because this is a tradition and a practice that has developed over many years. They must take a holistic approach. So that means holistic inside the prison, look at all the aspects and not only one or selected number of aspects, but they must also look at what happens outside the prison. In other words, what influences the profile of the prison population, for example, or how other government policies may impact on the prison. They should fulfill both the investigative and monitoring functions to provide accountability for past wrongdoing in individual cases and prevent future problems. But it's probably advisable in many instances that the monitoring function is distinguished from the investigating function. A few years ago, we participated in an international study to investigate what works in preventing torture. And so we looked at 16 countries. Myself and a colleague did the South Africa chapter. The other African country in the study was Ethiopia, but there were 14 other countries across the world. And what seems to, the findings seems to indicate that visits on their own don't seem to make a big difference in preventing torture. But when that visiting or monitoring mechanism service. In other words, it has the ability to refer cases for the prosecution to take further. Then monitoring visits appear to be more effective in preventing torture. And I think it's logical because it ensures accountability, or it assists accountability. Obviously, the agency under monitoring must cooperate fully. And the implication is that a refusal to cooperate must be an offense. Transparency and accountability are concepts that often come around in these debates about oversight and monitoring. And a lot has been written about it, and I'm going to see if I can summarize it in one slide. But transparency in our particular context would mean act visibly, predictably, and understandably. Officials' actions must be predictable and guided by policy, legislation, regulations, standing orders, and good practice. And when called to account, officials must be able to motivate their decisions and actions in a manner that is rational and justifiable. In other words, there must be no surprises here when a matter is investigated. With reference to accountability, we can make a distinction between horizontal accountability and vertical accountability. Horizontal accountability refers to those institutions that the state has established to control itself. So typically, the Human Rights Commission. It's there to look at how the state is behaving, and if there are problems, to report it. An ombudsman is another thing. Parliament itself is a way in which the state is held accountable at a horizontal level. Vertical accountability would refer to accountability of the state to an outside or an external agency. The electorate is an example of vertical accountability. Every 4 or 5 years, we go to elections, and based on the government's previous performance, we hold them accountable at the ballot box. But it may also be through the media. Investigative journalism has been increasingly prominent in the region, and it points to issues that are going wrong. And then, of course, treaty monitoring bodies like the Committee Against Torture. The UNSMR stipulates issues or requirements around whistleblowers and complaints mechanisms that we must reflect on. So the rules at 54, 56, and 57 deal with complaints, and that complainants must be protected. They must not be victimized because they lodged a complaint. And so there are ways in which to collect complaints to protect people from victimization, either by other prisoners or by officials. The rules 83 to 85 establish require the establishment of internal and external inspection mechanisms, and also that there must be access to external mechanisms dealing with complaints, such as national human rights institutions. There must be public participation and civil society involvement. I think it's important to consult the public and through and organizations that have a particular interest in prisoners and their well-being on legislative reform, and see if they have suggestions on how legislation can be improved and strengthened, and whether it covers the concerns adequately. Yeah, Bruce mentioned that. And then there must obviously be alignment with the international standards that I've mentioned already, such as UNCAT, the UN Convention on the Rights of the Child, the UN Standard Minimum Rules, and then also the Bangkok Rules. So those are our main international instruments. It does mean that international standards need to be domesticated in operational orders. So it is important that we take what the standard is, the international instrument, and see how do we make this make sense at operational level. If we then turn to the functions and structure of the oversight body, one needs to look at the composition and appointment of such a body, and the requirements there would be the obvious independence and autonomy of the body. The body needs to reflect pluralism, so there must be a good composition of men and women, for example, younger, older people, maybe former prisoners, maybe members from the judiciary, a health expert, a law expert. So there's a wide range of skills that are needed for effective oversight. There must be a transparent and merit-based selection process. If the appointments are made by the minister behind closed doors, it's not transparent. One needs to involve the public and say, we are calling for nominations. Those are the ideal requirements. There needs to be tenure and security of office. So yes, person is appointed for a particular period of time. There must be particular conditions for their removal. So let's say if they become incapacitated or gross negligence or something criminal, they may be removed from office, but there need to be clear rules for it. Some additional requirements could be, there must be citizens of the country or have permanent residency. Expertise in human rights would always add. There must be persons of integrity and have a record of impartiality. There's a need for professional diversity. And some may even set age and health requirements. So at least be an adult, must be sufficiently healthy to undertake visits that can sometimes be lengthy to far off places. So there may be those requirements. In respect of funding and operational autonomy, I refer to the Paris Principles on National Human Rights Institutions, and Principle 2 notes that and this is applicable to National Human Rights Institution. I'm not saying a prison oversight mechanism is a national human rights institution, but it helps us in establishing principles. So the national institution shall have an infrastructure which is suited to the smooth conduct of its activities, in particular adequate funding. The purpose of this funding should be to enable it to have its own staff and premises in order to be independent of the government and not the subject of financial control which might affect its independence. So we can distinguish between types of oversight mechanisms, and types of oversight mechanisms may not be the correct phrasing, but maybe these are focus areas that we can say we're talking about preventive mechanisms. So they are there typically as a lay visitor scheme to inspect and hear complaints and see how issues can be resolved that they don't reoccur. There are investigative agencies that would look at particular issues of suspected wrongdoing. And then there are systemic functions that would look at the performance of the executive in a broader, on a broader scale to see what the issues are. We can anticipate that there may be legal and policy challenges. And the first challenge would come from internal resistance from the correctional department or prisons department. These institutions are typically fairly secret about what they do, and they hide wrongdoing. And the same goes for the police and many other state institutions. So it's something that we can anticipate. And it may be a question of degree. There may be political and bureaucratic hurdles. If the country's constitution provides for an oversight mechanism or an inspection mechanism, as is the case with Malawi, that helps a lot. It's there in the constitution, it sets it out, these are the duties and functions, but it may not be that clear. And even the powers of members of parliament may not be that clear with reference to holding the exec accountable. So yeah, what are the powers given? And then how is the budget determined? What is that process? How clear and accessible is that? We can also anticipate that there will be resource and capacity constraints. And I think one must follow a pragmatic approach here and ask the question, what are the cost drivers and what are the priorities? And if we are accepting that, for example, communicable diseases is the priority, then we must look at what are the issues there and what we can do to alleviate that situation. There needs to be regular mandatory reporting against known standards, and that must be a minimum requirement. In my own experience of visiting prisons in South Africa and other parts of the world, it's really important that the officials understand, know, and are familiar with the standard of performance that is expected from them. The purpose of monitoring is not to catch people out. You rather want to say, this is the standard, this is what I'm going to look at. Do you understand that? And let's see how we can get to that standard if there's still not full compliance. But I think it's really important to be transparent in that way. Quantitative data, so statistics, are really useful and really powerful. because it communicates complex trends in a simple way. So if you show a graph and something is going up or is going down, based on statistics, or we say the average is this and we want the average to be that, these are useful tools in how we can advocate around resource and capacity constraints. There must be accessible information on the prison system. In the last couple of years, South Africa has slid back in the quality and accessibility of quantitative information on the prison system. It's hard work to turn that around, but basic statistics on the prison system is really important if you want to do effective monitoring and hold the exec accountable. It's a basic. Is there a problem with the translation? Oh, okay. So a few promising practices. Visits by justices are very useful, but I think the comment made earlier is that what do we expect of justices and magistrates? When do they become witnesses, and when is that a problematic situation? So, but nonetheless, it's a very established practice and it can be very helpful. And the question then is, okay, if justices are visiting and they are reporting, what are we doing with that information? I think it was Anneke mentioned that since the 18th century, justices in England have been visiting. Example there. In SADC, we know at least of 2 designated oversight bodies, being the Judicial Inspectorate in South Africa and the Inspectorate of Prisons in Malawi. A number of SADC countries have visiting committees and independent prison visitors. So these are typically lay persons who visit and monitor and hear complaints and so on. And these are useful practices, and I think they're really important to get people involved, get the public involved around prisons, because it helps. We know that in Ireland, there's been a visiting mechanism since 1925, and similarly in Scotland, England, and Wales. I put in prison protests as an item here, not because I think it's a promising practice, but rather because we need to be aware of this, that if issues shortly after the, well, in fact, in the run up to South Africa's 1994 election, there was uncertainty on whether prisoners would be able to participate in the first democratic election or not. And it was left literally to the last minute. And there was I think, one of our few presidential decrees issued that allowed prisoners to vote, and it calmed the situation down. But thereafter, there was an expectation that President Mandela would announce a general amnesty. And the expectation really was that the doors of the prison would be opened and everybody would walk out. But that was not a feasible option, but a decision was not forthcoming. Some actors in civil society mobilized around the issue and raised expectations and encouraged prisoners to protest. And riots broke out, and 36 prisoners died as a result of those riots, because this real expectation, whether based on fact or fiction doesn't matter, was not dealt with adequately and promptly. And we've seen elsewhere that where prisoners go on hunger strike because they're unhappy about conditions. So those are the things, the consequences that may emerge if our conflict resolution mechanisms and inspection and monitoring and reporting is not properly functioning. And then more countries are ratifying OPCAT. I think we are now 4 in SADC, if I'm not mistaken. But we are awaiting the results. So, where are we now in our legislative pathway? I think we are there on the 2 yellow highlighted items. We're still doing some desktop research, but we are also here today busy with stakeholder consultations. What lies ahead is that we must take this information and get it into a drafting process where we come up with actual draft law. And it may be very specific, or it may set certain principles, or it may give different options. We need to explore that. There needs to be a review and validation process, and that the SG has already confirmed. It needs to go to a plenary assembly, and then it is for domestication and implementation. So we can anticipate that there will be capacity building and training needs, and there will be different needs across the different countries. And one may possibly see how one can pool some of those needs for the sake of efficiency. We also know that there's a diverse range of stakeholders from the SADC Parliamentary Forum itself, the member states, national human rights institutions, the lawyers associations, civil society organizations, the bodies representing judges and magistrates, the funder in this case, and then also the International Ombudsman Institute. We also need to look at a monitoring and evaluation framework. And I hope this makes sense there. Yeah. And it essentially summarizes what we are working with here, is that we have international standards. And those international standards are reflected, or should be reflected, in objectives in domestic law. From those objectives, one should be able to lift policy themes, let's say around health or safe custody. For each of those, we need to identify one or more standard per theme. So what is the operational standard of performance? There needs to be indicators per standard and one or more measure of indicators. So this is not part of the draft law itself, but it illustrates how one would go about domesticating it and monitoring and evaluating performance ultimately. So the framework is what it is. It's a framework for a position paper. It's an attempt to be a bit of a roadmap to guide us going forward. And we can look at the major themes and says, yes, we agree with this, but we think you need to add this, that, or the other. Or no, we disagree. What about this? Or we need clarification on that. So I think the aim is to build consensus on what those parameters are. That will help us as the researchers a lot if we know, okay, this is what we need to look at, and we can ignore that. So essentially it asks the question is, what must be the scope of this model law? How do we set the borders for it? Thank you. I'll leave it on in case there are.
Thank you, Prof. You can see he enjoys prison oversight quite a lot. So it's taking, but I think by the end of this, we're all going to enjoy it. So can I take our first round of questions? I've got 2 colleagues there that can't see this from. So, thank you very much. Honorable from Seychelles, you can proceed.
Thank you, Madam Moderator. Good morning, everybody. Thank you, Professor, for the useful information you gave us this morning. While you were presenting, when you at point 1.3, when you talked about women are marginalized in a male-dominant environment, I was wondering what is the position for us to protect children? Because as you went along in your presentation, there was nothing mentioned about how do we protect children in prison. Will there be a different policy? Or will it go under something, another rule? I think we have to be mindful while drafting the model law that will also include children, the protection of children in the model law in prison. I thank you.
Very important. Thank you, Honorable. Honorable from South Africa.
Thank you very much. Good morning. It's Ntombovio Mende from South Africa. Thank you very much for the presentation and clarifications that were very much necessary in terms of the position paper. I'm more thrilled and welcoming the fact that you mentioning much more needed work to be done in terms of the monitoring tool framework that is going to be considered in order for SADC to monitor if this particular model law is going to be adopted, ratified, and implemented once it's done. Because the problem we have is that the ideas of model laws are very much necessary. However, SADC countries do as they please. And then we do not monitor if they actually implement that which we seek to do as SADC in order to have a more humane environment for prisons. Now, there is another area which I'm not sure if it has been canvassed or you will still look into it, because people that go to prison, they are within our communities. Firstly, what are the reasons that put them in prison? As much as now that they are in prison, they become a state responsibility. But how do we then prevent each state to jail as many people as we have currently? What are the reasons and how can that number be cut down to a number that's manageable by many countries? The second thing is the categories of crime and the reasons for justice to jail such people. So in terms of sanctioning by the courts, is it necessary by our justice system to jail a person for stealing a loaf of bread? Is it necessary for a prison to jail someone? Let me make a case of you are a parent, you enter your house, you find a rapist raping your child. Is it necessary to put that person in jail? So I'm trying to get to a point where we need to also look at the reasons why we're having so many people that are in jail, yet not necessary for them to be in that space. Another contributing factor is the capacity of justice. There's so many people awaiting trial. Once their matter is dealt with, the people are let go. Yet they are going to wait for more time in jail, like 2, 3, 4, 5 years in other instances, simply because there is no capacity in justice and prosecution in terms of dealing with the matter and processing it as soon as possible. That's another area we need to canvass and look at it as a mechanism within which we can utilize to lessen the number. Then the last one is the granting of paroles, which I think is one of the areas which in your broader concept paper is under 2.2 on different understandings of oversight. The granting of paroles, of course, we're going to look at the conditions and the reasons why the person was jailed to start off with, and the necessary process and consultation to be dealt with in order for certain people to be released in with parole, because there are SADC countries that keep people even cross countries in their jails for more than 20 years now, yet they are not there for murder, they are not there for what could be another very serious crime, murder, rape, or other hijackings, but they are there for crimes that are of less categories, yet they are in jails of other countries for more than 20 years. So that's another area that we need to look into. I do not know how we're going to canvass this one, because SADC health facilities on their own, besides the jail facilities, SADC health facilities, your clinics of infrastructural refurbishment and additional clinics, additional hospitals, additional human resource nurses and doctors and everything. So when we say a right to life, and in terms of the health facilities of jails, when we don't have health facilities for the general public in our countries, how are we going to juxtapose the two and make it a reasonable demand for the model law? Because if maybe we say there should be infrastructures in each and every SADC country, and not demand health infrastructures within the jails when we don't have proper clinics outside. But it's another thing to transport the prisoners from jail to a proper facility, because that's another requirement of human resource police and escorts and police day and night and all of those things. But there are things that we also need to be realistic in terms of looking at the broader picture of how the SADC countries and in terms of the health facilities. Thank you very much, Facilitator.
Thank you, Honorable. I can see you paid a lot of attention to the presentation. I'm going to ask Prof to answer those sets of questions. We're then going to break for tea and then come back for another, or you want to ask now? So after he's addressed those questions, we've got 2 hands and then we'll go for tea.
Thank you. To the Honourable Member of Seychelles, the question regarding children. Children are typically dealt with, and we'll bring it into the document, under the UN rules for juveniles deprived of their liberty, the Havana rules. So we'll bring that in and make it explicit in the UN Convention on the Rights of the Child, and the Articles 37 and 40 also deal with children in conflict with the law. And then there's also some spillover into the Bangkok rules, where mothers are with their infants in prison. And the African Charter on the Rights and Welfare of the Child refers specifically to children, infants, who are imprisoned with their mothers. So I'll bring those things in, but thank you very, very much. The first issue concerning the reasons for imprisonment, and I'm more familiar with the South African data, so I'm not picking on South Africa or anything, but my response may resonate with what is found in other countries, or it may not. Maybe South Africa is unique, I don't know. But if we ask the question, well, why are there so many people in prison? We need to ask the question, well, how many people are arrested? And in the case of South Africa, the South African police arrest around about 1.3 to 1.5 million people a year, or 1.5 million arrests per year. Now, that load of 1.5 million arrests are not distributed equally across the entire population. The police don't arrest infants, for example, or very rarely arrest children. They also don't arrest as many women. The arrest burden falls on adult men. So if we do the statistical calculations, and myself and a colleague did it a few years ago, you get a very interesting picture. If you're talking about South African men, adult men, so that's between the ages of 18 and 65, you get to a figure, and we were able to exclude children and women out of our calculations. We get to a figure that somewhere between 1 out of every 8 and 1 out of every 13 adult men are arrested in South Africa every year. So if we count 8 men down this year, row here, 1 of you would have been arrested this year. I think that's shocking. Distributed equally in terms of race, gender, race and socioeconomic status. That burden in South Africa falls on young black men. That's a fact. And so if you have people being arrested repeatedly and victimized by the police, it places them at risk of further imprisonment. So we are, through our arrest policies and practices, we are shaping the size of the prison population, and particularly the large number of awaiting trial people. There is in that another angle, that there are large volumes of arrests. There's a very quick attrition from the volume of people arrested to actual cases enrolled in the court, and then that figure drops further. So from the arrests, we see roughly from every 100 arrests, we see about 10 convictions. So somewhere along the line, you lose 90% of your cases, which is really inefficient. But what we've seen in the South African situation that is keeping our prison population fairly high is not the number of people being sent to prison, but rather for how long they are sent to prison. And we've heard that in 1994, we had 400 people serving life imprisonment. We now have nearly 20,000 people serving life imprisonment. So it's those type of things that is sustaining high prison population. One may also say, well, actually, we need in South Africa more people in prison given our crime rates. So there are many different angles to it, and one can go back and further and say, well, maybe it has to do with socioeconomic conditions and access to opportunities and poverty and inequality that is driving young people into desperate situations. So I think there's a real complex picture that we are struggling to understand, but more importantly, to get a proper response to. So in terms of the sanctioning, and you gave the example of a petty offense like theft of a bread or a chicken or something like that, there is across Africa, and it became a global campaign of poverty and status that was originally a campaign to look at the decriminalization of petty offenses. And it's a bit of history to it. We were doing research in, I think it was Malawi, and we came being a rogue and vagabond. And we thought, well, this is very strange, archaic language to find in legislation. And so we started looking at it and came across, and then discovered there are other examples of this. It happens in many other countries where people are arrested for strange offenses, that there are no clear victim. And so what I'm trying to get at is there is definitely a drive on the continent to move away from decriminalizing actions that either have originated from the colonial administration, that serve no real purpose except for gathering money for the state, paying fines and those type of things. and also criminalizing economically productive activities. So you're selling wares and things, but you don't have a permit, and then you get a fine, or you even get imprisoned for that. So I think there is a real sense of we must rethink this reliance on criminal justice to deal with socioeconomic issues, because it's typically poor people who are at the shortest end of the stick. You asked about the capacity of the justice system. Again, I'll speak to South Africa because it's what I'm familiar with. I think much more can be done to ensure that our courts are functioning in a productive, efficient, effective manner. And annually, the Chief Justice releases a report on the performance of the judiciary, and it's very helpful. One of the indicators there tells us that the average court time has dropped from 4 hours a day to less than 2 hours a day. And our own research have found that routinely cases are postponed for 7 days twice to deal with bail applications. And it begs the question, well, where's the sense of urgency about this person's right to liberty? Have we forgotten about that? So I think from a parliamentary perspective, there are things that we can look at and see and identify and use the information that is presented to us and say, well, what about this? Can we make this better? Can we at least have 3 hours of active court time per day? On parole, I stand to be corrected, but South Africa's parole system is fairly unique in SADC. Other countries have different release mechanisms, and it's something that I don't want to express any firm opinions on. I think it's one that one must look at and see how one would reflect on it in a model law, and what would an oversight structure look at with respect to what the appropriate release mechanism is, and how decisions are made, and maybe how those decision-making bodies are constituted. That may be part of the issue. And then lastly, yes, I think it will always be this competition for resources. People will always ask the question, well, if free society is so deprived of, let's say, health resources, why must prisoners have more? We must always remember it is the state that places a person in prison. The moment the state does that, it assumes responsibility for the well-being and the rights of that individual. That is a principle we cannot get away from. However, I think one cannot ignore the pleas from the public and say, well, what about us? And there are ways in which one can maybe reach compromises. And maybe if the honorable member from Zambia is around, maybe he or she can illuminate or confirm my observation from Zambia years ago, where the clinic at the prison functioned as the community clinic. It's a shared resource. And let's say, for example, in the morning, the prisoners would use it, in the afternoon, the public would use it. And those are, for me, sensible and efficient ways to deal with the challenges that we have in a resource-constrained environment. Thank you.
Honorable from Angola.
Muito obrigada. Eu queria, antes de mais, felicitar o professor Lucas por nos ter levado a uma incursão ao material que nos foi fornecido, e devo aqui garantir que, efetivamente, nós conseguimos ter uma melhor percepção daquilo que nós pretendemos, daquilo que nós queremos para essa proposta da lei modelo. Agora, há aqui uma questão que eu, de facto, que abordou, que são os obstáculos políticos e burocráticos, e esta também é a minha dos nossos governos, dos nossos executivos, essa lei modelo vai ser feita e ela vai ficar, é mais uma lei que não vamos utilizar. Então, me parece que precisamos criar aqui um mecanismo de comprometimento dos nossos governos para que eles estejam todos de acordo com aquilo que vamos fazer para que essa lei cumpra com os objetivos da sua elaboração. Caso contrário, nós vamos ter mais uma lei que vamos ter e não vamos domesticar as leis dos nossos países. Eu tive a ler, tive a ver com alguma atenção, por exemplo, a lei dos serviços penitenciários de Angola, que é de 2008, portanto, é antes da Constituição de 2010, em nenhum momento está lá a fiscalização pelo Parlamento. E nessa altura nós já tínhamos o Parlamento. Me parece então que, de facto, a vontade política dos nossos governos é muito importante nós enfatizarmos isso agora que estamos a discutir, e é também importante que no processo de elaboração nós integremos os nossos governos. Muito obrigada.
Oh, thank you, madam. And thank you, and thanks for the presentation. I mean, it has been clear that the overarching problem of the prisons is overcrowding. Sorry. The overarching problem of the prisons is overcrowding. And on your paper, on your framework for prisons, it has been clearly narrated that prisons are overcrowded, and the most overcrowded countries are South Africa and DRC. And it has also been identified here that it is also the case that few African countries have been able to invest in prison infrastructure. So clearly the issue of overcrowding is a challenge here. So my question to you would be, what other avenues can be identified to address the issue of overcrowding? And also, why can't we derive other avenues to solve the issue of overcrowding? And also, for the fact that we have a new economic war, it means that the state coffers are going to be to run dry in terms of managing the issue of overcrowding. So my issue is, Professor, how best can we try to address and resolve the issue? Thank you.
Thank you. The question from Angola is largely a political question that I'm going to engage with, as it is an expectation, something that must be dealt with in the SADC environment. But let me make one remark, and it goes back to my earlier point that essentially post-1990, we've seen broad-based constitutional reform. And that constitutional reform has not necessarily translated in the reform of enabling legislation, new prison legislation, for example. And perhaps that alignment of the constitutional framework is the commitment that is necessary, is the pledge that the honourable member has asked for. The next question, I didn't get the country from which the honourable member was.
Oh, Senator Mhale from Lesotho.
Thank you. Honourable member from Lesotho. On overcrowding, the obvious answer is, if we want to resolve overcrowding, is we must build more prisons. And and I'll come back to that. What we have also seen in the framework is that on average, 35% of prison populations in Africa, in SADC, are awaiting trial. Now that's a problem. My own view is it's too high. It needs to be at the most 20%. So theoretically, if you have 100 prisoners, 20 must be awaiting trial. If we can bring that figure down, we create 15 more spaces for sentenced people. Or alternatively, if we had 115 people, we can bring it down to 100 and we are within capacity. So the pretrial population is an important segment of the problem, because for them, they are firstly presumed innocent. And as I commented earlier, that these are people who are typically, and our research shows this, they are typically people who are economically active, who have dependents. They are sitting in prison for 3 months or 6 months or 9 months, and there's a household on the outside who is being adversely affected because they are accused of something. And that accusation is not being dealt with expeditiously. We can look at release mechanisms. There are particular sentencing provisions that allow for earlier release. So, for example, if you serve a sentence of less than 2 years, you only need to serve 1/4. If it's longer than 2 years, you must serve at least a half before you can be considered for parole. And even for people sentenced to life imprisonment, they must be considered after 25 years. So how people leave prison is something that one can look at and see, are there lessons that we can learn from each other. The sentencing policy, in other words, what are the sentences, is really important. In South Africa, it has had a profound influence on the profile of the sentenced population, but also we saw very clearly how, as a result of 2 things, the first was the change in the sentence jurisdiction of the lower courts, how that was increased. And what we saw then was that if you give a court an upper limit, they will sentence to that upper limit of their jurisdiction. So if you tell a court you were only allowed to impose a sentence of 1 year, but from tomorrow you can impose a sentence of 3 years, the court will utilize that 3 years as their upper limit. So sentencing policy and sentence jurisdiction are really important because it determines how long people sit in prison. Sentencing policy, in our case, introduced mandatory minimum sentences. And then to come back to the infrastructure, yes, infrastructure is a problem. And we can say, but I think one also needs to at some stage say, if we don't start doing something now, 20 years from now, many prisons would have literally fallen apart because they are so old. It's a difficult argument, but it's one that we cannot put our heads in the ground in forever. Thank you.
Thank you, Prof. I know there are many hands and we need to break. Also, I recognize the 3 of you for immediately when we come back. 4, 1, 2, 3, 4, 5. Can I make one point and ask one of our resource people to come in? Because just as a follow-up issue, in all the committee hearings, the issue of prison infrastructure has come up. And obviously there's a big issue around, can you build more prisons, and what is it going to, is it just going to increase the number of people who are imprisoned? But we do also at the same time acknowledge that there's terrible infrastructure that causes health hazards, that's not ready to equip to deal with climate change, and that is basically inhumane. When we look at prison oversight, this model law cannot tell every prison, every country must immediately build a new prison and have everything up to scratch. But as a country, and if parliamentarians have oversight, parliamentarians can ask every year, let's see how many of our prisons don't meet the minimum standards. Let's see how progressively we can every year at least improve one prison. But to do that, you need the data, you need the information about what's going on in prisons. So the model law is not going to say build more prisons. The model law is going to try and create a mechanism for parliamentarians to come up with a plan on how to get all facilities eventually up to minimum standards, if that makes sense, because we recognize different countries are in different positions, and obviously there's a lot of issues that people have to consider. The issue raised by the honourable member from South Africa about how to, the honourable member from Lesotho, my apologies, about how do we actually deal with overcrowding, and Prof. Munting mentioned sentences. And I want to ask one of our resource persons, Judge Ntaba, to come in here, just to give you the Malawi example, because even there, the High Court it's a huge problem that we delegate to magistrates. Magistrates are based in the community where they have to do that sentence. They go for the highest you don't need in prison. But then the processes to deal with that problem become itself a difficult problem because the High Court has to review and everything. Quickly, one comment by Judge Ntaba on that.
The thing about sentencing is you also have to realize that these sentences are coming from the concept of that it's society that decided that what sentences should be. So it's not necessary, and it's always, the issue is always that it's the problem of the justice system. But it is an issue that we created because we set those sentences. So the issue with sentencing that we've also realized is the concept that you must recognize that magistrates sit in the communities. Now, if you are in a rural area, the stealing of a bicycle is huge because a person has saved all their money for that. And as such, they are looking at that concept. While if I'm dealing with a bicycle offense in town, I will not look at it at the same way. I will equate that to a car. So when sentencing is happening, sentencing is looking at the circumstances of that crime and the area that crime is happening and the frequency of it. So even if it might be a crime of want or a crime of need, the circumstances matter. Even a chicken, people rear chickens for Christmas. They start from way back. So it's the same way if you are going to a village chief's court, you will understand that the concept of a person who's stolen a chicken, he'll be asked to pay for that chicken, but even asked maybe to give 2 more chickens for it. It's because of the value that it is given in the society that it is in and in the context. So when we sentencing is a myriad of issues. So that is why we always look at all concepts. But we do realize that our sentencing parameters are wide. You can have community service. You can have suspended sentences. You can reduce certain offenses. You can decide to warn a person. But that is the problem with the criminal justice system is everybody only always looks at the courts. But these are parameters of diversion or warning can start from police. They don't need to start from us. So the system is clogged because the system has started from the concept of the arrest, which is an arrest that's coming from the village all the way to the criminal justice system. But there are mechanisms that we're all trying to do to decongest the criminal justice space. So that's what I could say for now. Thank you. Connect.
Thank you, Judge. I recognized 5 people. Those 5 people, I promise, will speak after the tea break. I beg of you to fetch your tea, have a quick comfort break, and come back in 20 minutes so that ending the session by lunchtime. Thank you, everyone. Honorable members, if we can take our seats, please. Thank you. Hi, everyone. If we can take our seats, honorable members, please. Can we all come back inside, please? Honorable members, can we please start? Welcome, everyone. Thank you. Can I ask, if you haven't yet signed the attendance register, please do so, including the resource persons. So just before the break, I recognized the hands of 5 individuals. Can we start on this side with people's comments? I'll start on the top and work my way down. Madagascar. You can go.
Oui, merci de m'avoir donné la parole. Donc, avant toute chose, permettez-moi de remercier le professeur Lucas de nous avoir exposé les éléments essentiels à savoir sur cette loi type de la SADC. Et je peux dire que c'est vraiment un sujet complexe et dépendant de plusieurs facteurs politiques ou autres, mais surtout du système judiciaire et l'organisation de l'administration pénitentiaire de chaque pays. Et permettez-moi de vous partager ici, de partager devant cette auguste assemblée, en fait, les expériences ainsi que notre point de vue à Madagascar concernant le sujet. Je tiens à préciser quand même que, avant d'être député, j'ai exercé en tant que magistrat dans les tribunaux de Madagascar et durant 5 ans, j'étais secrétaire générale du ministère de la Justice malgache. Donc, le sujet dont on parle ici, j'ai un peu d'expérience et de connaissances à la matière. Et Madagascar, tout d'abord, salue l'initiative du Forum parlementaire de la SADC visant à élaborer cette loi type sur la surveillance des prisons. Et cette démarche s'inscrit dans une dynamique régionale de renforcement du contrôle parlementaire des lieux de détention. Elle vise également à garantir le respect des droits humains des personnes détenues, leur dignité ainsi qu'une meilleure prise en compte des groupes les plus vulnérables, notamment les femmes, les enfants et les jeunes. En tant que pays engagé dans la promotion des droits humains, de l'égalité de genre, de la protection de l'enfance et membre actif des instances du Forum parlementaire de la SADC, Madagascar considère cette initiative telle qu'une opportunité d'harmonisation juridique, mais également un levier stratégique pour impulser des réformes nationales fondées sur les droits humains des personnes détenues dans la région SADC. Et ce processus revêt une importance particulière dans un contexte où, bien que des efforts ont été déployés, les infrastructures pénitentiaires sont souvent, telles que ça a été dit depuis hier, héritées de la période coloniale et peinent à répondre aux standards internationaux de dignité et d'humanisation de la détention. Notons ici que Madagascar dispose d'un arsenal juridique encadrant la détention, que ce soit préventive ou la condamnation définitive, des droits des détenus. Notamment, il y a le Code de procédure pénale qui limite la durée de la détention préventive avec des possibilités de prolongation. La loi qui renforce les droits de la défense et qui stipule aussi que la détention préventive représente une mesure exceptionnelle. Un décret qui organise l'administration pénitentiaire et qui encadre l'enregistrement, la surveillance, l'inspection, le contrôle et le suivi des personnes détenues. Et il faut également noter que des organismes publics et des organisations de la société civile qui œuvrent en matière de droits humains disposent des mandats pour effectuer des contrôles au niveau des prisons. Il s'agit par exemple de la Commission nationale indépendante des droits humains, le Haut Conseil pour la défense de la démocratie et de l'état des droits. Et il y a également dans nos droits positifs des dispositions qui parlent de la commission de surveillance au niveau des établissements pénitentiaires, c'est-à-dire des commissions qui sont chargées de inspecter la salubrité, la sécurité, la nourriture, l'organisation des soins, le travail, la discipline au sein des établissements pénitentiaires. Et il y a aussi la possibilité pour les juges et les procureurs de faire des contrôles à tout moment et surtout sur la situation pénale des personnes détenues. Il y a également les services de l'inspection de l'administration pénitentiaire qui peut travailler dans cette démarche. Et comme il a été dit par le professeur tout à l'heure, c'est vrai que la loi type n'obligerait pas les États à construire les nouveaux prisons, mais pour notre part, au cours de ces dernières années, je tiens quand même à mentionner qu'il y a des efforts qui ont été faits dans la construction de nouvelles infrastructures qui répondent aux normes de Mandela. On a construit 10 établissements pénitentiaires, des maisons de haute sécurité. Il y a 3 maisons de haute sécurité qui vraiment répondent aux standards internationaux. Et ces infrastructures ont été saluées par la Commission internationale de la Croix-Rouge qui ont assisté en 2024 à un atelier sur l'infrastructure pénitentiaire en Afrique qui ont eu lieu à Tananarive avec la participation de 15 États d'Afrique. Et ces efforts traduisent une volonté politique de transformation dans un contexte souvent marqué par des contraintes infrastructurelles et budgétaires. Mais l'institutionnalisation d'un mécanisme parlementaire et national et régional pour la visite, le contrôle et l'évaluation réguliers des établissements pénitentiaires implique forcément des mesures d'accompagnement. Et dans un esprit de coopération nationale, régionale et respect des normes internationales, nous souhaitons formuler des recommandations concrètes à intégrer dans le processus d'élaboration de cette loi type de la SADC. Et ces propositions reflètent à la fois les réalités nationales malgaches et les engagements internationaux du pays en matière de droits humains, d'égalité genre et de la protection de l'enfance. En premier lieu, nous souhaitons qu'il y ait une inscription explicite des besoins spécifiques des femmes, des jeunes et des enfants dans le projet de la proposition de loi type de la SADC que nous allons émettre, et ce, en conformité de règles de Bangkok, de la Charte africaine des droits et du bien-être des enfants et de la Convention des Nations unies sur les enfants en conflit avec la loi. Ensuite, nous souhaitons l'institution d'un mécanisme à ne pas empiéter le principe de séparation de pouvoir, car nous savons que dans un État de droit, nous, en tant que parlementaires, nous devons savoir les limites de nos actions de contrôle et que les actions que nous allons effectuer au sein de ces centres de détention. Troisièmement, nous souhaitons l'adoption ou l'inscription dans ce loi type, en fait, de l'adoption par chaque État d'un régime semi-ouvert pour les établissements pénitentiaires. Semi-ouvert, c'est-à-dire que les détenus peuvent travailler dans la journée à l'extérieur ou à l'intérieur des prisons, c'est-à-dire dans les champs ou dans les entreprises. Et le soir, ils vont retourner dans leur cellule pour pouvoir dormir. Quatrièmement, nous souhaitons également qu'il y a dans cette loi type ce qu'on appelle désagrégation systématique des données relatives aux personnes détenues, que ce soit par sexe, par âge ou statut judiciaire, afin de mieux orienter les politiques publiques et afin de mieux aussi exercer le contrôle et le suivi par nous, parlementaires. Cinquièmement, nous souhaitons le développement des mesures alternatives à la détention. C'est très important que ce soit pour les mineurs, pour les femmes, et ça va privilégier la réinsertion sociale, socio-professionnelle de ces enfants ou de ces femmes, la réinsertion éducative et la réinsertion familiale et communautaire. Et sixièmement, nous devons réfléchir profondément sur ces peines alternatives à l'emprisonnement pour les pays qui n'en disposent pas encore. Par exemple, à Madagascar, actuellement, nous proposons une loi sur les travaux d'intérêt général. Les travaux, les prestations à la communautaire, c'est très important, je pense, pour lutter cette surpopulation carcérale que nous avons dans la région SADC. Il y a également ce qu'on appelle le contrôle judiciaire, c'est-à-dire au lieu de mettre en détention préventive les prisonniers, et on les oblige à se présenter une fois par semaine devant le juge pour qu'ils puissent être contrôlés. pour les mineurs, il y a ce qu'on appelle le placement dans les familles d'accueil ou les centres de réinsertion des mineurs. Donc, c'est très important pour éviter en fait que ces enfants subissent les problèmes physiques dans les prisons. Il y a aussi l'institution de procédures extrajudiciaires qu'on appelle la médiation ou l'arbitrage. C'est surtout pour les mineurs en conflit avec la loi. Et il y a la réparation matérielle des dommages causés ou la restitution, et ça rejoint en fait cette application des peines qui a été dit par notre collègue honorable de Malawi tout à l'heure, que chaque peine doit être appréciée selon les circonstances et le contexte géographique de chaque pays. Et il y a aussi un point que j'estime vraiment très important à parler en ce qui concerne le droit de vote des personnes détenues. Je pense que ce serait souhaitable que c'est à chaque pays d'en apprécier la pertinence parce qu'il y a plusieurs facteurs et contextes de chaque pays qui sont différents. Et pour le cas de Madagascar, il faut préciser que la condition d'éligibilité même d'un candidat à un mandat électif est subordonnée à la jouissance des droits civiques et politiques. Et une personne ne peut être candidat si la personne a été déjà condamnée pour un crime ou un délit. Et la perte des droits de vote reste encore parmi les sentences au niveau de nos juridictions. Donc, c'est un peu compliqué d'imposer ça, mais je pense que c'est à chaque pays d'apprécier l'opportunité. Et enfin, nous souhaitons vraiment le renforcement de la coopération interparlementaire, notamment à travers des visites croisées entre pays membres, l'élaboration d'un manuel de bonnes pratiques régionales et l'organisation d'échanges entre les différentes commissions. Et pour terminer, Madagascar, que nous représentons ici, réaffirme notre engagement pour une détention respectueuse des droits humains, des normes et des principes d'égalité, bien que nous estimons quand même que des réflexions préalables, et j'insiste sur ça, en matière d'infrastructure, des conditions de détention, des formations des personnels de l'administration pénitentiaire et des réformes du système judiciaire doivent être adoptées, et nous sommes prêts à contribuer activement à l'élaboration de cette loi type régionale et à porter, si besoin, les réformes nécessaires au niveau national. Merci.
Thank you, Honourable Member. And I want to commend the Honourable Member for highlighting best practices. And I think that's up to all of us. And even if you don't get an opportunity to speak here now, this is an ongoing process. I ask members to please email also at any time best practices or things that you think are really important to include in the model law. And if there's examples of oversight mechanisms that you think work very well, we can even adopt that specific wording. So feel free to send that through. There will be best practices outlined in the final position paper. And then obviously there'll be some of those will then be translated into model law itself. So thank you very much. Can I ask, there were two more in this row. You want to go for it?
Thank you very much for the opportunity, Honorable Chair. I am Honorable Nogutula from the Kingdom of Eswatini. Professor, in your presentation, you mentioned independent prison visit. I noted that oversight should also benefit the families that visit inmates, in that where there are cases of prison visitors being harassed, or kept waiting and caused to pay a price in whatever way this may be picked up, ensuring that families are not punished for the incarcerated. On the same note, Professor, imprisonment should only speak to depriving a person of their rights to movement. Why are families not allowed to bring in food for their incarcerated family member if they can afford that? Why is food made to be part of the sentence? Or it's still the colonial treatment that you have to do away with? I thank you.
Thank you. Excellent point. Honourable from Zimbabwe.
Thank you very much. Honorable members, mine is more of a comment than a question. We appreciate this landmark model lawmaking process. We need to address the fundamental challenges that we need as a region. We need to beneficiate our rich mineral resources to ensure that there are more jobs created and also that there is lesser crime. We need regional cooperation to build solid economies that absorb a lot of people who tend to crime. And let's embrace ICT to reduce crime. I thank you.
Thank you, Honorable. Honorable.
Thank you very much for offering me this opportunity to comment on the role model in SADC countries. Most of the problems we are grappling with here can be dealt with by decongesting our prisons. One way of doing this is by revisiting our laws and scrap off all those laws which are deemed to be petty. I have a good example in my country, Malawi. By the way, my name is Francis Piso from Malawi Parliament. For example, in Malawi, when it was noticed that there was a law called Logi and Vagabond, which police were required to arrest those people who were deemed to be walking free at night, maybe coming from a drinking spree. And at the same time, those driving were left scot-free. When it was noticed that this was one way of the prisons were overcrowding, because in a week, over 100 people can be arrested for this petty issue. Fortunately, it was scrapped off, and this has helped to decongest our prisons. So as SADC states, we can agree to look at those petty laws which mostly affects the poor and leave the well-to-do people free. The other thing is to look at the judiciary. I have to be very careful because sitting next to me is her lordship in Malawi. So I have to be very careful what I'm going to say here. If we can look at the sentencing, I remember Malawi Supreme Court judge, his lordship, Justice Kalembera, indicated yesterday that it is in our constitution that the courts should also give community sentencing, like one has to be required to go and work at hospitals and other public institutions instead of custodial sentencing. But in most cases, you will find that, especially in our rural courts, in magistrates, they are not in favor of this community work sentencing. They prefer one to be sentenced in custodial sentencing, which lead to overcrowding in our prisons. Because if we change the way we are doing things, we'll find that instead of complaining that the budget is not enough for our prisons and the like, if we decongest, the same amount of money can cater for a small number of prisoners. So it's high time the SADC states should also look at the sentencing. Maybe come up with a point saying, oh, those sentenced less than a year or so should not be given custodial sentencing. Because if you are sentenced to less than a year, that means it's a petty offense. So if we can agree that maybe we should be encouraged that under those circumstances, people should work, and because also the community will also benefit but if the person, the offender, is working, is the assist. I remember there was a case in Malawi whereby a lecturer, a professor actually, was sentenced to, I think was it 3 years imprisonment, but the judge ordered a non-custodial sentence saying he should lecture at a public university for 2 years without getting any salary. That was a unique case, but if you look at it carefully, you find out the community benefited from it. Because here's the professor who was lecturing at a university, public university, without being paid, which at the same time, he was serving his sentence. So as SADC states countries, it's high time we look at these two important issues, because in the end, you find most of the problems we are struggling with will be sorted out. And before I finish, I would like to say my question that in most cases, we sit down here, we discuss things and agree, we go to our countries, present it in parliament, and suddenly it ends there. There no more action. In my case, if our team goes back to Malawi Parliament, we make a presentation in Parliament, the Parliament will adopt it, and thereafter, the follow-up is nowhere there. It ends there. So maybe it's high time as SADC PF states should find a way how to enforce, to see that what we have agreed is indeed being followed. In short, that's my submission. Thank you.
Thank you, Honorable from Malawi. Are there any hands I've missed? From South Africa, yes.
I'm a substitute for my South African colleague who had his hand up. Thank you very much. Just 3 quick points for me. Prof, I think for me, there's a point that was made by the colleague from Madagascar on really learning from each other in terms of the best practices, because one appreciates the fact that we are not at the same level in terms of the mechanisms and structures that are in place to do oversight. Maybe my direct question to you, Prof, is what can we learn, good or bad, from the Judicial Inspectorate of Correctional Services that we have in South Africa, which is, headed by former Judge Edwin Cameron at the moment, which can assist us really to firm up the model law that we are busy with. Because I believe, we've been having this institution now for the past 27 years. And I think it's worth asking a question whether is it making impact or not? And the last point that I want to make is that perhaps it's going to be important for us in our respective member states to echo the sentiments of my colleague next to me, that we really focus on looking at socio-economic contributors that are filling up our prisons, rather than making a call for us to build more prisons. Because Prof made the point that what should be the solution here? Should we build more prisons because the current one are overcrowded? or should we do something else? Perhaps looking at, just like my previous colleague has said, looking at interventions to ensure that people with, minor criminal offenses don't end up in jail. That could be one way. But of course, as I said yesterday, where I made an example of, in our case in South Africa, where we have about 2,600 people who have been granted bail, but they cannot afford it because of poverty. And that bail is less than 1,000 rand for all those people. So there are a number of areas that we can look at to try and deal with the issue of overcrowding. But I think more importantly, we've got to look at factors that are contributing to people ending up in prison and really focus on those which are largely socio-economic challenges in our respective member states. Thank you, Chair.
Thank you. I'll start with the honourable member for Madagascar. Thank you for those diverse comments and suggestions and ideas. I think they're very helpful. I'm not going to deal with them individually. Perhaps just 2 points to lift from there is, going forward, it may help us to move from a position where we say we are taking multiple approaches to prison oversight within a country, and that it's not only Parliament, but it can be Parliament with justices, Parliament, justices, and members of civil society. So that diversity in responses, I think, may in the end be to our benefit. The issue of infrastructure keeps on coming up. Maybe we'll host a separate discussion on that, because I think it's a really interesting point. But for me, it's also a question of how do we cost infrastructure, and how do we align the cost and capacity of the prison system within the national budget. And can we, for example, say, and I'm just using South Africa here as an example, to say, let's assume for a moment that the South African government decides it wants to have a prison population of 150,000 people, because that is what we have space for. Not really, but let's say we have, of which not more than 20% must be awaiting trial people. So we set very clear targets, and we can adjust those targets over time to adjust for population growth and all those things. But that government, or the criminal justice system at least, work towards particular targets, and that there is a coherent effort. I think the risk is if we allow prison populations just to increase organically because we think we can't do anything about it. And that's a fallacy. We can do a lot about the size of a prison population. It's government policy that determines the size of a prison population largely. So the member from Eswatini raised the issue of food. And why can't families bring food? My own experience here is that there's no restriction on families bringing food to unsentenced prisoners. That they can do. It will obviously need to be searched. Normal security restrictions apply. All prisoners can also buy additional food from the prison shop. That is a contentious issue of itself, but let's say that is fine for the moment. Where the restriction is placed here is on food requiring preparation for sentenced people. My understanding is that if the family members of sentenced prisoners come to visit, they can bring food along, more like snacks. And if it's a contact visit, they can enjoy the snacks together. So that's not the issue. It's not a case of taking the food to the cells for consumption afterwards. It's one of those things where I think one can raise a variety of issues, but I fear the prison administration is going to come back and say it's for security reasons. That is why we're restricting it. The flip side of it is that one can accept that if the prison administration provide an adequate and nutritious diet that meets the normal and special requirements of the particular prisoners, be they are high on protein or AIDS adapted diet or whatever the case may be. If there is those requirements are met, I think it would be difficult to make a case for food to come in. But we know that in many countries, the administration only provides one meal a day. So over time, prisoners' health deteriorates because they're simply just not getting an adequate nutritious meal. So it's one of those things that one will need to look at the particular context and see how one moves on that. I don't think there would be any issue in developing. I'm fairly confident there are minimum standards in this regard, and one can consult them and make reference to them, perhaps in accompanying memos to the model law. The comment from the honourable member of Zimbabwe is noted, relating to jobs and crime. The honourable member from Malawi mentioned the offence of rogue and vagabond and law reform processes that have been taking place in Malawi. And Malawi has very much been at the forefront of the decriminalization of these petty and colonial era offences. Especially the rogue and vagabond and loitering offences dating back to colonial times, I think they are particularly offensive for those very reasons, that they essentially determined who, based on their profile, can be where at what time. And what place does that have in a democracy 50 years later? Then see my own notes here. The question from the member from South Africa regarding what can we learn from the Judicial Inspectorate for Correctional Services. I think there's a lot that we can learn from things that were done well, but also from mistakes that were made. And it's always a good point to start with the Constitution. And what we see in the South African Constitution is that it's in a bit of a cumbersome, if not clumsy way. The Constitution provides for police oversight, but it does not provide for prison oversight. I looked into this question in a fair amount of detail and spoke to people who were present at drafting the Constitution, and they don't know why they excluded it. So it's one of those quirks of history. So it would have been helpful if it was written into the Constitution, as is the case with Malawi. I think a positive point is, and was perhaps a bit of a trying to solve a difficult situation, is to say that it must be a judicial inspectorate. It must be headed by a judge of the High Court to give it at least an appearance of independence. And maybe there was too many expectations of that function. because even though it was headed by a judge of the High Court, it was still sitting firmly within the Department of Correctional Services, who controlled the budget and administration and staff. And the first batch of staff was in fact seconded from the department to the inspectorate, which meant the seconded staff knew exactly who the boss was. On the positive side, the inspectorate very quickly established a system of, initially they were called independent prison visitors and later renamed to be independent correctional center visitors. So these were laypersons from the community who met some minimum requirements, who were then tasked to visit prisons and hear complaints and see if they can resolve that. I personally took the opportunity and became independent visitor at Drakensberg Maximum Prison. It was a very formative experience in my own life. So I think that principle of involving the community is an important one, and something that one can put through into the model law. The other thing I think the inspectorate did quite well over the years was to put a lot of information about the prison system in the public domain through its annual reports, but also through its quarterly reports to the Portfolio Committee on Correctional Services and later Justice and Correctional Services and now Correctional Services again. So those public engagements about what's happening at operational level and telling members of parliament, this is what we have observed. We've raised these issues with the department. They are not responding to us, or we've raised it and this is how we fix it. I think those are very valuable lessons to be taken forward. As with regards to prison capacity, I think I've spoken to it part. But the size of a prison population is a function of how many people come in and how many people go out and how long they stay there. So if you have legislation enabling very long sentences, people are going to stay there. I think what one would like to aim for under ideal circumstances is that the prison population should be predictable. In other words, that we are working within a plan, within a strategy, and we know we want to keep it at this level, but we accept that it may increase to that level over a 10-year period, that there's some predictability around it, and it's not something that is happening 1 year it goes up and the next year it goes down, because that makes planning also difficult. Thank you.
Thank you, Prof. Can I take another round of hands? Is there anyone else who wanted to ask anything? If not, I want to give the floor to our resource persons to actually come in with some additional insights, and then we can perhaps take another round of after that. Can I get an indication from the resource persons who wants to say something? I've got Jeffrey, yes, and the colleague sitting next to you. Chikondi, I've seen your hand. Boxton, I've noted your hand. Anyone? Dr. Magwende, I've noted your hand as well. Okay, thank you. We'll start on that side.
Thanks very much. Good morning, everybody. It was just a few comments, not so much on the model law, but some of the issues that came up. The issue of children in prison, I mean, which wouldn't be part of the model law. I'm not sure how many countries in the region have child justice acts. In South Africa, we've had one for some time, and it's basically trying to keep children out of correctional facilities, trying to keep them as far as possible out of the criminal courts. So there would be involvement of social workers assessing the situation, There would be diversion programs for them to go on, and if they complete those successfully, then their charges would be withdrawn. But I think it's something, what I'm highlighting is it's maybe something for the SADC countries to look at what are the systems that are working in those countries. I do remember in the course of the few days hearing somebody saying in their country, and I can't remember which one it was, that prison, in terms of the court, children are not allowed in prison. We haven't gone as far as that in South Africa. The emphasis is for them to go to secure care facilities, but particularly for the older children who have committed serious crimes, they can be imprisoned. But the numbers of children in prison have dropped in South Africa, have dropped substantially. Professor Munting and I were actually discussing around, is it working? For the South African members of parliament here, the Department of Justice is meant to submit an annual report to parliament on the implementation of the Child Justice Act. But anyway, the bottom line on that is for other SADC, when it comes to children, for other SADC countries to look at what are the systems, what could be done in their own countries. Then the issue of Professor Munting had raised the problem of police arrests. And again, I don't know how much this is a problem in other SADC countries, but in South Africa, as you said, the police arrest a large number of people. A part of the problem is that the police measure their success in terms of the number of arrests, rather than the number of people that are enrolled in court and the number of people that are found guilty. So he did speak about that, but just to say it varies in different parts of the country in South Africa, depending on how enthusiastic the police in a particular area are. I was told at one point, for those of you who know East London, that there was a problem there. On a Monday morning, the magistrates' court would be full of people because the police would have arrested lots of people over the weekend. But then on the Monday morning, the prosecutors would go through the evidence and decide it was not enough to charge people. So the vast majority of them were being released. But it is to be arrested, to be kept in custody, even for 1 day overnight, is disruptive and doesn't, I think, help you to become a model citizen. The last point I wanted to make is that the issue of remand detainees is a problem in the whole region to differing degrees. I had noticed that Malawi has the percentage-wise the smallest number of remand detainees in correctional facilities. And I think that other SADC countries really should learn from Malawi and find out why is that happening. I understand that certain interventions were made in Malawi, that it wasn't always the case, but everybody has said that being a remand detainee is a problem. You're not yet found guilty, but often there would be pressure from the community that people should not be given bail. But anyway, everybody would agree that the quicker that these cases get finalized, the better. And let's see what we can learn from Malawi. Thanks very much.
And on that note, I'm handing over to Justice Ntaba. There's a reason we have many Malawian resource people here. I think it's one of the countries that have really worked hard in reducing pretrial detention, and part of that is because there's a lot of oversight happening. So Judge Ntaba, give it over to you.
Thank you. Let me highlight the oversight that's apart from the prison oversight. There's also major judicial oversight on a lot of the matters that deal with remandees as well as the prison sentences. With remandees, one of the biggest oversight is that for a lot of common law countries, we have a provision which mandates police officers to continuously advise the courts as to the number of remandees that they currently have, so that they should ensure that the numbers are reduced and people don't overstay. And a lot of times the CRMs, the PRMs, our magistrates try as much as possible to ensure that the numbers are kept low. But we also highlight, even within the magistracy, as well as the High Court, this concept of camp courts, they also undertake. So it's not only a High Court intervention, it is also a magistracy intervention. And if you realize, in all of our countries, the biggest bulk of our criminal justice system is done in the magistracy level. So we can't only do one interventions at the higher bench, they also have to be done at the lower bench. So camp courts are also part of magistrates' work. So that's something that also ensures that people can go into prisons and deal with the cases as they are at that particular point. The other judicial oversight we have is it's also a common law provision that a lot of us with common law country who have inherited the Civil Criminal Procedure and Evidence Code that was in the UK, the issue of review, apart from appeal, review and confirmation. For confirmations, it says every sentence above 2 years, it must be sent to the High Court to either be confirmed as legally appropriate, or to be overturned depending on the circumstances. So the High Court in Malawi will sit on confirmation for all the cases across the country for any offense that is over 2 years. But when we were doing these exercises as the High Court, we realized there's a problem on only restricting it to 2 years. Because the other offenses, as we're talking about, the 6 months where people should have been sent on community service. So we pushed down, we stopped using the 2 years and said every sentence should be sent, whether it's a fine, whether it's a community service order, all those particular parameters, they must be sent through. So that has also helped us in terms of reduction in terms of the number of people that are in prisons, as well as oversight over the magistracy, where a lot of our bulk of our cases come from. In terms of the recommendations that we're looking at in terms of oversight as well, when you're looking at the prison oversight law, our suggestion, or my suggestion would be, it doesn't just stay within the prison oversight, but also looks at the detention centers. Yesterday, there was an issue about jails. There are also other detention centers. If the recommendation is that, there has to be also another parameter within the recommendations that looks at that people in prisons and detention centers should have access to legal aid. And I think this is something that we constantly, as people who sit on the bench, asking of our parliamentarians, that look at the legal aid budgets. The legal aid budget, because we realize most of the people in prisons are poor without legal representation. Now, if they are poor without legal representation, it's only if the legal aid budget is well funded can you have people coming out of prisons. Malawi currently went into the Legal Aid Bureau. We changed our Legal Aid Act to the extent that you have, is it 8 or 9 districts now that have legal aid bureaus in them? Those legal aid bureaus are actually helping us reduce the numbers because you have more representation of people in a district who can access a lawyer, or at the very least a paralegal that is paid for by government and not always paid for only by civil society, which will depend on donor funding. So we are hoping that by the end of, I think, 2 years, I said, they'll roll out in all our 28 districts, these legal aid bureaus. That is a significant issue. If you're talking about justice and how we can decongest prisons, you must invest in legal aid. And the final one would be, when you look at policy reforms, the judiciary also has a major role. One of the things that the deputy ministers just talked about is this sweeping exercise that happened over the weekend. The weekend is the best time where police officers push their numbers. So the case was before me. The case was people would be swept, and when we were being swept, they would be swept for the petty offenses, rogue and vagabond, idle and disorderly, being found public nuisance. It is offenses that are very, very overly broad. But they can just find you at a bar, you're drunk. Of course, you're going to be drunk at a bar and rowdy. They will take you, you're in prison Monday, you're before a court. And in most times, because these people are unrepresented, they'll be charged also together. One general charge and they will plead guilty, which means they go either they were fined or they're going, if they can't pay the fine, they were back in the system. So we also took out the sweeping exercises. We said, if you're going to do a sweeping exercise, you must do a sweeping exercise that fulfills fundamental issues. What is the rationale for the sweeping exercise? It's just not to arrest everybody. It must have a purpose. You must then charge everyone with the right offense. You can't charge everyone with idle and disorderly. Not everybody is being idle and disorderly. If a person is found with a dangerous weapon, charge them with the dangerous weapon offense, but don't charge them with idle and disorderly. And not only that, don't arrest everybody, because you can't arrest just everybody because they're poor. So it is fundamental that you look into the systems, you look into your laws, the offenses that actually, as South Africa was asking, where's the contextual issue? What is putting people in prisons in our countries? It is the fact that they're poor. The police are assuming a lot of powers, and that is also congesting our prisons. And it's something we need to look at. And one final issue on women. I wanted to highlight a fundamental case that I did. One of the things that you realize about women in prisons is the inability to understand that judges have powers, magistrates have powers to not just to suspend, but to start a sentence at a later time, as opposed to the time that it's been given. We had a case where a woman went into a market, she was pregnant, she stole a purse that had like 2,400 kwacha, a cell phone, which the value of it would have been less than $50 at that time. She was arrested and was given about 6 months in prison. She was heavily pregnant. Because we have the right to review, and the review powers that we have as judges of the High Court is on our own motion, or somebody can refer a case to us. So this case was referred to us. It was referred through the prison system. So the prison system also can refer cases. They have to have the ability to have that interaction with the judiciary to say we can refer cases. So they referred that case to us. When it came before my court, my registrar just had one simple rule: this decision must come out today. Why it must come out today, she did not mention. I reviewed it. I suspended her sentence, gave her a warning. She was released. I delivered that ruling at 4:30. At 7 o'clock, she gave birth. Our prison system cannot handle those kind of issues. I did not know these. I only knew she was pregnant. How pregnant she was, I did not understand. But I knew that the system couldn't handle it. So the review process, all the mechanisms have to work together. Prisons have to also be able to come into the system, into the justice system, and alert justices and magistrates on what else can be done about the congestion in their prisons and the people that are vulnerable within their systems. So I just wanted to highlight that for you.
Thank you, Judge Ntaba. It's the benefit of having people in the room who have experience coming from lots of different spaces, because you start seeing where all the gaps are. I'm going to ask Chikondi Chijozi to say something.
Thank you so much, Anik. I think for me, I would just highlight one thing that we had already talked about yesterday, that this process, we are not reinventing the wheel, but we're trying to make sure that the standards that have been set by the laws in our countries and at international level are being adhered to. I think it's important to have that at the back of our minds, because most of our legislative framework do have the protections that we're talking about in terms of vulnerable groups, general for prisoners, but the challenge is that those laws are not adhered to the letter. That's why we are having these challenges where prisons are overcrowded. Prisoners don't have the basic minimum needs that they should have. So what I would urge members is that when we are developing the model law, let's also look at against our existing legislative framework, so that when you're going to do your oversight over the prisons, you're looking against what is already there and enforcing the law as it were. I'll give you an example. I was sharing yesterday when I appeared before Parliament. One of the members of Parliament was concerned that there are so many foreigners in our prisons in Malawi, and that why is it that these people cannot go and serve their sentences in their country so that we lessen the burden on our prison system. But the previous Prison Act has always had the provision that the minister can actually issue a license to a foreigner or a prisoner who is a foreigner to go and serve their sentence in their country. And I believe that even in other jurisdictions, there are those provisions where the law already provides for how you can decongest the prison through the powers that are given to the minister. So if you are going to visit a prison and you find that there are so many foreigners there, you have now to check, has the minister exercised their power to decongest the prison by issuing licenses? Are they issuing those licenses? My 20 years working in prison, I've never heard of a minister license releasing a prisoner. But we've had one prison in the north of Malawi, which has a capacity of 300 prisoners, and we've had more than 300 foreigners in that prison, meaning only foreigners filling over the capacity of the prison, which the minister could have exercised those authorities. So when you do the oversight, you look at things like that, instead of saying, oh, let's change the law. You might want to change the law that already exists. So I just wanted to highlight that. The second and last thing I want to highlight is on the building of more prisons. I think if we are going to talk about more prisons, it should be about improving the conditions or reforming the existing structures to meet the minimum standards, but not necessarily to deal with overcrowding. Because all the time, evidence has shown if you build more prisons, that prison is going to be filled up again. In Malawi, we had the one prison in the north, Mzimba, which was supposed to be a model prison for Malawi. And it's the only prison that has got beds because all the prisoners in Malawi sleep on the floor, bare floor without mattress, nothing. So they built the Mzimba prison to be a model prison, which had bunk beds. The first month that the prison was built, it was filled over to capacity with other prisoners sleeping under the bed. You see, so it doesn't really solve the problem because the issues of overcrowding have nothing to do with the capacity. It's over-reliance on detention or incarceration as a form of punishment when we have so many other forms of punishment that we can consider. So I just wanted, as members, we discuss or do the oversight, we shouldn't be thinking that let's build more prison because it never works. Thank you.
But we should fix the current prison.
Yes, let's fix the current one to meet the minimum
Okay.
standards. Yes.
Yes, Dr. Magwende.
Thank you so much. When I listen to all the deliberations, I think it's very clear that we seem to be mopping the water while the tap is still running. And I think for a long time to come, we can keep mopping for as long as the tap is on, it will never dry. I did ask a question yesterday when I was making my submission to say, are we able to fix the prison conditions without looking at the socio-economic imbalances? And I think the honorable member of South Africa did allude to that in one way or the other. I think we have so many petty cases in our prison settings simply because of the socio-economic imbalances that exist on the outside. It would be very interesting, again, to learn more from Malawi when the Lady Justice was trying to share their strong interaction with police, with the prison departments as well. Out of their strength or strong interaction, what is the percentage of the remandees in their establishment? I think it would be very good to learn from that. Because I mean, in the region, we have about 30-35% remandees. Apart from building new infrastructure, like Chikondi alluded to, I think we need to also look at alternative sentencing, releasing those that are deserving, strengthening the parole system, decriminalizing minor offenses, and also to pay much attention on restorative justice system, where the victim offender mediation mechanisms are employed, community-based solutions, and so on and so forth. Unfortunately, Madam Chikondi, we will need to build more prisons, more to replace the existing, because I still contend and I submit that the infrastructure that we use today, we inherited from a system that did not have rehabilitation in their aspirations. Rehabilitation is us who are thinking of it, but we are using the same structures that we inherited. When the punishment is meted on these inmates by the courts, they do not say you'll be deprived of fresh air, you'll be deprived of bathing or sanitary conditions. No, but those are the structures that we are using. Thank you so much.
Thanks, Dr. McGuinness. I think your comments come specifically from a health perspective. And as we make these arguments, the health arguments are extremely compelling. The fact that we have 100 prisoners in a cell with a window that's completely blocked up and no natural light, and then they're detained there for 12 to 15 hours. Things like that, which obviously exacerbates health, public and impacts on public health. So there's many arguments that support the process that we are involved in now. I want to take it, we've got 2 more resource persons left, and then I'm going to ask if there are any other questions from the members. I want to just ask Mr. Kudziwe if you have any final comments.
Thank you, honorable members. My final comment is more or less like what Dr. Mangwende has already alluded to, the issue of social or economic situation in our respective countries. I'm coming with this comment just because in the model law, Professor Lucas mentioned the issue of the capacity or the drivers that influence the prison populations. So it is good for this honorable house to look onto our plans, both the long-term plans and short-term plans, as we are targeting the youth in our countries, because majority who are flocking onto prisons today of the middle class, the youths, who barely going around in towns, in villages, without anything to do. Thank you.
Thank you. Mr. Mwango.
Yeah, good afternoon, members. I want to talk about the prison oversight. At least we have heard from the presentation by Professor that it's Malawi and South Africa that have got prison oversight, that's prison inspectorate in their countries. I think it's very important for other countries to take the same route. It is unfortunate that ours in Malawi, despite coming in 1994, but as we are talking now, we don't have the secretariat. And even when it comes to the funding issues, we were at the mess of the Malawi Prison Service, who were getting money from the prisons and thinking of allocating some money to us. We didn't have our own vote, but we are glad that since we have just passed the prison bill, there's a mention of us having a secretariat in the prison bill. So we are hoping that we are going to have the secretariat. So I'm saying this because I know maybe you might attempt to have yours. I think you should consider all these that there are challenges, when you members of parliament, you are allocating resources to institutions. I think what comes in your mind is when there's a proposal for prison department, I think you don't consider that as something worth supporting. So we have struggled in Malawi when the prison department are formulating their budget. The actuals versus what they are given by the parliament, you find that it's not balancing. Most of the times they trim the budget as if in prison they don't have people who use to buy food each and every day. So I think just a call to make sure that you should also prioritize prisons. My father was working in prison. I've actually grown in prison. I've seen the different types of prisons, and I've seen so many people. The most important, the VVIP coming to prisons. So today is someone else, but tomorrow it will be us. So let's make sure that I think we should make the prison not as a hotel as Justice Ntaba and Kalimbra say, but it should be have humane condition that a person can live. That if you can be picked today to go to prison, you can live. And actually the most prone people that can go to prisons, they are the politicians. Thank you.
You couldn't resist saying that. So I've got honorable member from South Africa. Is there any other honorable member who still want to say something before I hand back to Prof. Munting? In that case, honorable member from South Africa.
Thank you, Chair. And the presentation by the Prof as well received, and the former Deputy Minister. My question is simple as well. I just want to find out the role of the African Court on the human rights and people rights. Human and people rights. Because we've got African Union as well. We've got all these bodies, and their job is to make sure that they adjudicate matters dealing with the state compliance with the African Charter and other instruments on the protection of human rights ratified by the state. So my issue is, when it comes to the inmates or the prison rights as well, we should find out exactly what is their stand. Because we hear most of these so-called international court. And when it comes to African courts, for me, from where I'm sitting, perhaps I might be wrong, but for me, I'm seeing a lot of bodies being toothless. Where they are needed the most to make sure that we protect people's rights and human rights. Because some countries as well, perhaps by design, because of the system, they are found wanting, and they don't want to follow the basic human rights. Hence, we are where we are today. As I said yesterday, that we've got 25% of remand, we call it waiting trialists. They are remanded by the courts. And my last parting short, Chair, is to say the issue that the judiciary is always correct, or the magistrates are correct, or the judges are correct, is unfortunate. Because they erred as well. As I said, some people are being sentenced wrongly. They are spending part of their lives in jail. And it's unfortunate that if these bodies I've mentioned earlier, that there's no oversight from them. They are just there to meet, in hotels and, workshop, seminars, and that's it. It ends there. They come back the next following year. We discuss these matters. No actions taken. We still have the overcrowding. We still have this people's right being, those prisoners being abused. I mean, as I said, I was traumatized of what I've seen. It's not for the first time. If you go outside, you see these photos there. I hope in the next, because us in South Africa, we're in the 7 administration. By the time we leave here, we'll have these waiting trialists, perhaps less than 10%. But this is exactly the issue which has to be addressed by all the SADC members. Because it's not a case where it's only Malawi and South Africa where you have overcrowding. Recently in Mozambique, you know what happened. And I'm saying, let's improve, let's not be a talk show as well. And just meet for the sake of meeting, we discuss issues, the executive ignores all our concerns here. Because we are not representing ourselves here. We are representing our countries. So I hope that the executive, when we go back, they'll be able to take notes of this, and as lawmakers as well. If we have to amend policies and regulations and all these laws, when we meet again about this matter of pre-prisons, at least we will have a better outcomes than what we currently have. I thank you, Chair.
That was a very appropriate comment, I think, Honorable from South Africa. And I am equally worried about the fact that things don't change. And I think all of us here are. We should never have, I recognize you, we should never have a situation where post-apartheid, post-colonialism, we are where we are, and we have democracies, and we have constitutions, and we have all the soft law that exists in Africa, that Africa developed at the African Commission, through the African Court, through all our jurisprudence at domestic levels, that are very clear that these conditions are entirely unacceptable. What we've recognized is that I think everyone passes the buck because it's such a complex problem. And the idea with a model law would be to think creatively about how can one have mechanisms in place that actually ensure that these things don't just remain the same, that people highlight it constantly, that we constantly are aware of what's going on so that we're not surprised by it one day. And that we actually have timeframes and action plans and ways in which to ensure that there's accountability, and even and that people who do perpetrate this don't go on forever without being held to account. So I think this has all been a very positive development, and I equally beseech everyone to not to go argue this in your own countries. We are definitely willing from the SADC Parliamentary Forum side and the consultant side to come to any of your parliaments to use evidence from your own countries on why these initiatives are so important. And we can support you in whatever way you want to be able to, and our intention going forward with the model law is also to have consultations with various role players to figure out where exactly the blockages are. If you speak to someone from legal aid or someone working in the prison or someone working in parliament, or a judge, the answer is always a different one. So we need to come to something together that actually deals with these problems. And I feel we've got the ball in this room to do that. So thank you. There was one last comment from the honourable member at the back. Yes.
Excellences, mesdames et messieurs, bonjour à tous. En fait, j'aurais souhaité juste faire une suggestion. Nous connaissons chacun les réalités et les possibilités de nos pays respectifs, et je propose qu'on inscrive un but qu'il nous serait possible d'atteindre ou de mettre en place afin de nous rapprocher beaucoup plus des besoins de la loi cadre. Je ne sais pas si c'est réalisable parce que les possibilités de l'Afrique du Sud, par exemple, ou du Malawi, ne sont pas du tout les possibilités ni les réalités de Madagascar. Donc, nous mettre des buts à atteindre. Voilà, merci.
Thank you, honourable member. Anyone else? Going. Doctor, Prof, final comment.
Not sure why I'm getting the last words, but I'll try and use the opportunity. One or two things that I thought may be useful. The first is there's been some informal discussions about terminology, and in some countries the term prisoner has fallen out of favor. We can spend many hours deliberating this, but I think as consultants we can put a proposal in a draft law, and then we can see how members react to that. My suggestion would be the term inmate to refer to all people in a prison, and one may also look at the term prison and maybe look at correctional center or a different word, and then remandee to refer to people who have not yet been convicted and sentenced, and sentenced inmate to refer to a person who is serving a sentence term of imprisonment. We will obviously have to consult with interpreters to get the correct meaning for the French and Portuguese. But that would be our suggestion forward, and we can take input on that once we've developed a draft law. To the honourable member of South Africa, who I think asked a very valid question: what is the purpose of all these courts, and especially the African court? And it's a very short anecdote that Salk and us and others brought an application to the African court for an advisory opinion on the constitutionality of loitering laws in Africa. And the court opined that these laws are no longer compatible with the provisions in the African Charter. And so one asks the question, so, okay, what's the value of this? I think it's important because it sets the tone for countries across the continent to look at their own legislation and constitutional provisions and say, well, we have the backing of the African court's opinion on this if we want to change it. So yes, it adds to the momentum on this particular issue around decriminalization. I think that's important. Then lastly, I was chatting to somebody from Swaziland, he calls it Swaziland, the night before last. And he reminded me of something called the residuum principle. And the lawyers in the audience would be familiar with it. But in South African law, it dates back to a case in 1911 that appeared in the appellate division, as it was called then. And to cut a long story short, the court came to the conclusion that a prisoner retains all their rights except for those rights that need to be limited to implement the order of the court. And that is fundamental to our understanding of imprisonment. It's only those rights that need to be curtailed to implement the order of the court. Unfortunately, the South African forgot about this principle for many years, and it refeatured in a Supreme Court of Appeal decision around about 1993. And that decision, Hofmeyr versus the Minister of Justice, is fundamental to shaping our understanding of imprisonment and jurisprudence. So I'm also saying that it can take very long to bring these changes about, but we must persevere and persist. So thank you very much.
Thank you, Prof. I'm sure you're going to see a lot more of him in the coming months ahead. I want to call Professor Vern Harris. At the back, Mr. Harris. We are honored today to be joined by someone from the Nelson Mandela Foundation, and we thought it was particularly appropriate for this convening to close on that note. Mr. Harris will introduce himself and do more justice to it than I possibly can. So I'll hand over to Prof. Harris. Thank you.
Good afternoon, everybody. Thank you. It's a pleasure to be here with you, and I'm grateful for the time that you're giving me. What you're discussing here is particularly important for us at the Nelson Mandela Foundation. I've had the privilege of speaking to Nelson Mandela Madiba many times about the years he spent in prison, the battles that the political prisoners had to fight. And I was also privileged to be part of the team that worked with the United Nations to have what is now called the Mandela Rules adopted. So I wanted to share with you just a few reflections which might be helpful to your deliberations. I worked with Madiba from 2001 and spent a lot of time with him in a role I was given as his personal archivist. So looking at his personal notebooks, diaries, correspondence, and so on. And I thought what I would share with you today, just very briefly, is 3 items from our archives. And I'm going to ask if we could, we're going to watch just literally, it's 4 minutes of footage of Madiba talking to me. This was recorded in 2006, talking about his prison experience. Thanks.
Apologies for the sound. We'll sort it out just now.
communicate with them?
No,
and those
that's true.
struggles?
It was easy, you know. I spoke Afrikaans better in jail because I could practice it every day. And
Tell us a bit
then,
about
you know, the
trouble
warders,
in 1977, when the journalists came and took
they
that
are
photograph of
not
you, we can
highly
see you were very
educated, many
angry
of
there.
them. And they received many letters. No, actually, with complaints from I wasn't various people. And they would then come to me to help them. That's how I picked up Afrikaans very quickly. Because they were actually being cheated.
Right.
Yeah.
Right.
You know, the extent to which whites cheat other whites.
Apologies. Thank you for your patience.
Madiba, can you tell us a bit about the trouble in 1977 when the journalists came and took that photograph of you? We can see you were very angry there.
Yeah. No, actually, I wasn't angry. What disturbed us was what the authorities were going to do after the journalist had visited us.
Right.
Because they used to treat us very tough. But when there was an important visitor coming, then they would relax. They would say, oh, no, you don't have to work continuously. You can just take a walk if you want to around the quarry, and then we knew that a visitor is coming.
Right.
But once the visitor is gone, oh Christ, the same cruelty would be mobilized. And they were difficult those days.
So you knew it was a propaganda?
Yeah, no, we knew. And we didn't compromise at all. We challenged them throughout. And we knew when a visitor was coming, when they were now treating us nicely.
Right.
But we never relaxed with them.
Right. Thank you. Can you tell us something about your struggles to get letters to family and friends? We know they were censoring letters, and a lot of letters didn't ever reach the people
Yeah, quite.
who wrote to.
Well, at first we were allowed to write and receive letters once in 6 months.
Right.
And, but of course we fought against that for quite some time. And the methods we used, they really could not tolerate. And so we eventually won the battle.
You learned Afrikaans while you were on Robben
Yeah,
Island?
that's true.
And did you learn Afrikaans so that you could communicate with them?
No,
and
that's
those
true.
struggles?
It was easy, you know. I spoke Afrikaans better in jail because I could practice it every day. And then, you know, the warders, they are not highly educated, many of them.
Right.
And they received many letters with complaints from various people. And they would then come to me to help them. That's how I picked up Afrikaans very quickly. Because they were actually being cheated.
Right.
Yeah.
Right.
You know, the extent to which whites cheat other whites. I didn't have a full measure until I was in jail. And I had learned Afrikaans. Then I realized how cruel they were.
Now, Christo Brunt was different, though, wasn't he?
Oh, yes. No, that's true.
Did you become a friend of his quite quickly, or did that happen over many years?
Oh, no. You know, Brandt was a very interesting youngster. They would say something to him, the big chaps, confidentially. And then he would come to us and make sure that I'm not there. And if I'm in another group, then he would tell others what they say about me. But they were talking to people like Kathrada.
Yes.
And when he goes, then they tell me what they were saying.
So he was like a microphone for you to hear what...
one more technical difficulty. Apologies for the technical difficulties. You can see I was a young person then. That was a long time ago. I just wanted to give you a sense of Madiba speaking for himself. That is in our archive. And you could tell that I was sharing with him documents and asking him to reflect. I want to share two other documents just briefly. The first one has to do with the work that was done by the International Committee of the Red Cross. They visited Robben Island regularly over many years. And in 3 particular years, an individual, his name is Dr. Morellon, Jacques Morellon. He kept very detailed notes of his visits to Nelson Mandela in particular. And he donated these notes to us. The one note I wanted to read to you is from the very first time that he visited Madiba. So this is in 1973. Morellon goes through various issues related to prison conditions, and he names them: food, clothing, hygiene, medical assistance, study, recreation, work, correspondence, visits, and relations with warders. He then goes on to say, on each of these points, Mandela made precise comments, never speaking of himself, but always of and for others, except on one point. He had pains in the back and found that the sisal mat he slept on. So at that point, the political prisoners were not allowed to have beds. They did not have mattresses. They just had a sisal mat that would be rolled out. And he said, especially in the winter, he did not find this mat helpful. That's the actual words Madiba used. Morellon goes on, I told him that I would try and get him and possibly others in a similar situation a bed, which I managed to do, although it took 2 years. So by 1977, and you heard Madiba talking about that visit by the journalists, a group of journalists went to Robben Island to see the conditions in 1977. By then, Madiba had a bed and even a pillow. Then the third extract, and I'll kind of stop at that point. You heard Madiba talking about correspondence and being allowed to write one letter every 6 months initially. They fought hard to be given what the prison system called privileges, not rights. An incredible document that we have in the archive is a notebook that Madiba used on Robben Island to draft his correspondence, because those letters could only be 500 words. So he would draft a letter, count the number of words, then make his changes, and when he was happy, he would rewrite the letter on paper that would be sent out. Now, I just want to read to you an extract from one letter that he wrote in 1971. This notebook disappeared from his cell in 1971. He demanded it be returned. He never saw that notebook again until 2004, when a former security policeman brought this notebook to the foundation and gave it to him. But I want to read to you a letter he wrote in 1969 to his daughters, Zenani and Zinzi. Zenani was 12 years old, Zinzi was 10. Madiba had not seen them for 7 years. And he writes to them, I was happy to learn that Zeni can cook chips, rice, meat, and many other things. I'm looking forward to the day when I will be able to enjoy all that she cooks. Zinzi says her heart is sore because I am not at home and wants to know when I will come back. I do not know, my darlings, when I will return. You will remember that in the letter I wrote you in 1966, I told you that the white judge had said I should stay in jail for the rest of my life. It may be long before I come back. It may be soon. Nobody knows when it will be. But I am certain that one day I will be back at home to live in happiness with you until the end of my days. Do not worry about me now. I am happy, well, and full of strength and hope. The only thing I long for is you. But whenever I feel lonely, I look at your photo, which is always in front of me. He had another 20 years to go when he wrote that letter. The political prisoners were not allowed to receive visits from family members under 16 years of age. So he still had another few years to go before he would be able to see Zenani and Zinzi. I'm sure you've heard that story about Madiba, that narrative that he came out of prison without bitterness and embraced his former enemies. That's not the Nelson Mandela I got to know. He had a deep well of woundedness, anger, but he chose to channel that anger in constructive ways. Mamuni, who I got to know as well, she had an even deeper well of woundedness. She had been tortured in prison, and she found it very difficult to channel her anger. The work that you're doing here in this context, just these few items I've shared with you, becomes very important. And we're grateful for the work that you do, and we wish you well in the endeavor. Maybe just to end off with one other reflection. The International Red Cross official that I was quoting from, Morelon, he does also reflect on how Nelson Mandela was able to write Long Walk to Freedom on Robben Island. This was done in 1975, 1976. And that manuscript was smuggled off Robben Island by Mac Maharaj when he was released from prison. But it was a copy that was smuggled off the island, and the original manuscript was buried in coffee tins by the political prisoners. The authorities found those tins and were able to determine from the handwriting that it was Madiba's manuscript, but also they could see the handwriting of Walter Sisulu, Ahmed Kathrada, who had also given notes and comments. Because of that, Madiba was, and the others, were denied what was called study privileges for 4 years. And on a lighter note, Madiba continued with the studies, and he got a degree in 1989, just before he came out of prison. I'm sure you know. I mean, the question for you is, what was Madiba studying in prison in 1989? Well, you know he was an attorney and set up a law firm with O.R. Tambo. But what you probably don't know is that at that time, in the 1930s, 1940s, you didn't need a law degree, an LLB degree, to be an attorney. You needed a bachelor's degree, then you needed what was called a BProc, effectively a postgraduate diploma in law, and then you did your articles. Madiba registered to do the LLB degree in 1943, and he got that degree in 1989. I wonder if you want to guess how many exams he failed along the way. 35. And in the archive, we have a sound recording of the journalist Rick Stengel talking to Madiba in 1992, and he said, "I see your law studies didn't go so well. Is that because the lecturers were racist?" And Madiba said, well, some of them were, but that's not why I did badly. And then Rick said something along the lines of, well, the struggle came first, and then you were in prison. And it must have been very difficult to study in the conditions that you were in. And Madiba's response was, no, Rick, we have to be frank about these things. I was a poor student. I tell you this because the quality that we at the foundation, and I know this for other colleagues, but speaking for myself, the quality that Madiba had, that we found so inspiring, and that we find most inspiring now when we're faced by so many challenges in our country, but in the continent globally, is that quality of resilience. Madiba talked a lot about hope, and in that letter to his daughters, he said he was full of hope. But what we have learned from Madiba is that hope is not enough. We need something more than that. And that something more is a belief that we fight the good fight, even if we lose. It matters that we fight. It matters that we conduct ourselves properly and that we don't give up. That's a value that the foundation is wanting to share with all our constituencies, all our stakeholders, and people around the world. Good to speak to you. I'm happy to, if there are any questions or observations, I'd be happy to answer. Thanks very much.
I don't know if I should open the floor for questions. It's almost, I know this is very traumatic for people to hear, and it speaks for itself, really. And I think having seen this right at the end leaves us with an understanding of the weight that is now on us to make sure that this doesn't happen to other people. With that, and this is a bit of an anticlimax, I'm going to hand over to the SADC Parliamentary Forum. Mr. Qureshi, if you can come up. I'm going to ask him to very briefly explain to us what's going to happen from here on. And then we will have the closing remarks of the Secretary General. And I know we all need a few deep breaths after Prof's presentation, and I hope he joins us for lunch so that we can engage him further on this as well.
Thank you, Anneke, for the opportunity. I want to share, colleagues, if you would allow me. Okay. Oh, okay. Yeah. Thank you very much. And I couldn't have taken the floor at a better time than after him. There are many quotable quotes that he put across, but I like the last bit where he says, hope is not enough. Sometimes hope is not enough. But what matters is that we are fighting a good fight, even if we lose. Honorable members, I want to talk to you, but especially to your hearts. One of the reason why I start with this slide is that sometimes when you are leaders and are dealing with difficult situations or tackling challenges, it's very easy to be overwhelmed. And you lose track of the milestones that you have made. We have a challenge. In my other role, I do mentoring of young people. And I often tell them, don't do like we have been taught to do, especially as Black people. we have borrowed meekness, where sometimes we are not ready to claim credit for the things that we have done and done well. And honorable members, through SADC Parliamentary Forum, we have been trailblazing in terms of tackling some of the difficult things that we are confronted with as a region, and you have been solution finders. When you look at that trail in terms of where we have come from and the work that you have done, beginning with the model law on HIV and AIDS in 2008, the model law on eradicating child marriages and protecting children already in marriage, the model law on elections in 2018, model law on gender-based violence in 2021, the model law on public financial management in 2022, and currently we're doing the model law on prison oversight. We also have on the horizon the model law on constitutionalism and rule of law. That does not say you are fighting a fight that you are losing. So it is important for us to remember the successes we have made and build on those. One of the things that is clear, Anik and colleagues, is the cross-cutting nature of the focus of our model laws, where one commentator has actually said through model laws, SADC PF is actually either building or contributing to building the regional Bill of Rights. SADC PF parliamentarians have been unequivocal in terms of your contribution to the Bill of Rights in the SADC region. And therefore, this process, which is why Aneke asked me to speak, this process, what we are doing must be seen in the context of contributing to these pillars. We have inverted the process a bit in the sense that, as you will see when I explain, yes, we ordinarily would then have involved members in validation, particularly during the drafting stage onwards, where we then, after the draft is ready, we bring the draft for validation by the joint sitting committee. What we did this time around was to find an opportunity to bring members at the very soon after initiation, where we are raising awareness so that honorable members, you are in the know. I'm sure you would appreciate from our deliberations that we've been dealing with a multiplicity of issues, multifaceted issues where sometimes even the sense of overwhelming comes through. But we need to channel our processes and our thinking in terms of the model lawmaking process, where we are now going to be finding opportunity in terms of because the initiation is already done, we are implementing a plenary assembly resolution. So there is already a standing resolution from the plenary assembly. So the question of, do we need a model law is no longer a question now. It's a question of saying, how do we do it and do it effectively? So we are in we have the 4 stages, namely the initiation, which I spoke about, the drafting stage, the approval stage, the domestication stage. And linked to this, I think to make this more clear is that we will be rolling out a roadmap, obviously, covering all these stages so that we are able at committee level, at individual level, to see how we become more intimately involved in the processes. And if at any level you wish to engage the Secretariat to see how best you can be more engaged, that remains an opportunity. But as I conclude, let me focus my effort more in terms of the lessons learned, in terms of the lessons we have learned over the period when we have developed the model laws. And honorable members, particularly old-timers like Honorable Salishando, will know and will be familiar with some of the issues that I'm going to raise. One of the issues is the issue of time. When we developed the first model law, obviously we did not have a lot of experience, but more importantly, when you look at the evolution that has happened in terms of access to information, so the model law on HIV and AIDS took much longer. The rest of the other model laws have seen efficiency gains from experience, but also information being available. The other important aspect is the issue of research foundation in terms of existing research and regional and international frameworks being available to guide that process. Then the issue of expert involvement. One of the things that we have done at SADC Parliamentary Forum, and honorable members would be aware of this, we have the technical working groups. We also have subject experts. We even bring drafters from member states when we are doing the process. And this process is not going to be any different. We will have to tap on the technical working groups and the other expertise, other experts that we have. Another important aspect, we are a parliamentary institution. Our legitimacy comes from citizen endorsement. And so public engagement is very important. One of the common threads that runs across all the stages of our model lawmaking is the involvement of citizens. Then the other aspect is the issue of timing. Timing is everything in model lawmaking. One of the things that you see, Anneke and colleagues, is that opportunities for domestication sometimes are happening parallel to the development of the model law. So, honorable members, if there is a legislative review in your countries, meanwhile we haven't finalized the model law, you should not hesitate to reach out for us to tap from the resource that we have by way of our experts to be able to already credit the model lawmaking process with contribution to what is underway. So we need to look out for opportunities. And honorable members, because they are the ones that are dealing with these issues at national level on a daily basis, we rely on you to proactively reach out to the Secretariat through the SG and say, can we benefit from the resource so that we are able to make more impact? Then the issue of coordination and communication, because it's going to be a process that involves different stakeholders, particularly you as parliamentarians. We also then need active coordination process, and we have a very robust mechanism of keeping that process. And these colleagues you have seen here, you continue to see for the next 2 years when we are working on the model law process. Another important aspect that I could flag in terms of the lessons learned is the importance of the position paper. The colleagues kept on talking about the position paper. Whenever when you have a position paper, honorable members, you don't need to worry about the questions that you may be asked, because that position paper is precisely meant to respond to those issues. And we will make sure that we package it into different knowledge tools that you can readily use so that you are able to respond to any of the issues that may arise in terms of conceptual clarity, in terms of foundational understanding, strategic direction, the baseline, in terms of the contextual framework. Everything will be contained in that policy paper. So it's our model lawmaking process structured to carefully make sure that we have a concept paper. Lastly, the issue of media involvement. We live in an era where there is disinformation. So deliberately having sources of accurate information is not optional anymore. So the media plays a very important role. First of all, in terms of accountability, where they will raise the obligations, the demand accountability in terms of existing obligations. Then the issue of advocacy, we need to soften the ground. We need to engage policymakers, and the media becomes a handy tool in terms of all its various forms, social, conventional media. We also need authoritative sources of information. I talked about misinformation and disinformation. Then, of course, it is about the people, raising public awareness, linking with the citizens. I do not want to take much longer, but let me conclude by just highlighting some of the stakeholders that we are going to be engaging, and in so doing, put to the fore the issue I raised earlier, the importance of communication and coordination. And therefore, we are going to need you, honorable members, to be actively engaged with the process. And that's why the Secretariat was deliberate this time around. Instead of bringing you at the end where you are waiting for the final product, we brought you at the beginning where you are actually collectively running with the process. And so the question of where to from here, it's exactly as I outlined in terms of the steps that we follow, where we have done our initiation and the consultations. We are moving into drafting stage. After that, we are going to do validation, and then we take our model law to the plenary assembly for adoption, following which we now start a real work, which is domestication. And we thought this would help honorable members to have clarity in terms of how do you channel your energies, and what do you look out for in terms of where we are and going forward in terms of the model lawmaking process. Thank you very much.
Thank you, Mr. Kurash. I think you've managed extremely well to bring us all onto the same page and ready for this process. And with that, I'm going to hand over to the Secretary General for her to give us our closing remarks and to end the meeting. Honorable Secretary.
Thank you very much, Anike. Honorable members, I believe our facilitators and our staff deserve a round of applause, including yourself, as we end this session. Hello? Hello?
We can hear you, Honorable.
Okay, Ronald, probably pin that because I only see a mic. Okay, thank you very much, Anike. Honorable members, allow me to just stand on the protocol that was established at the beginning of the session, and just allow me to say, honorable members, honorable speakers in our midst, dear colleagues and distinguished participants. Honorable members, as we close, I just wish to register our profound appreciation for the attentiveness and transparency that you've demonstrated in all the deliberations concerning the issue of prison oversight. Honorable members, we appreciate further that these deliberations often expose some complexities and intersectionalities on issues that do impact on prisons and certain populations. Thank you for your enriching contributions and interventions, which really have made the joint session a tremendous success. I believe, honorable members, that from now, we have the right information to finalize the framework for the position paper, the outline for the model law, the outline for the consultations, and refine the outline and the legal provisions that would enable us to consult further with the relevant stakeholders, as already alluded. I'd also hasten to indicate that, as already indicated, the position paper is key, honorable members. This is what we would disseminate for you to share with the relevant chairpersons of committees responsible for the various areas that you think may be critical. It's a document that you'll also table alongside your report on the reasons why the model law is critical, why taxpayers should invest in this process. The model law will also share or contain evidence which will assist you in your debates, in your advocacy, as you solicit the relevant stakeholders. Honorable members, as we end, it is important to keep focus that at the SADC Parliamentary Forum and also at the SADC level, we are yearning for deeper regional integration. Deeper integration means that economically, our laws must be aligned so that goods and services can be exchanged at arm's length with competitive advantages. At the same time, deeper integration also means that socially, we must attempt to subscribe to the same norms which would bring our citizens closer and make our different societies recognizable to one another. We have done so, as indicated earlier by Mr. Shodine Kuresha, with the model laws that we have developed. One such incident that brought us closer together was the model law on eradicating child marriages and protecting children already in marriage. And I'm pleased to report that the majority of SADC members have adopted certain provisions that prohibit child marriages. They've also been able to recognize that 18 is the age that a child can contend with marriage, which really brings us closer, the closeness between countries with similar coherent norms. Honorable members, seen from this macroeconomic perspective, it is important for the region to develop through normative standards, which can inspire national parliament to amend domestic law and bring harmony to national laws prevailing in SADC. Incremental steps must be taken to ensure that different fields are harmonized, be it on gender-based violence, election on public financial management, or even prison oversight, and other fields that are explored by the Forum for Model Lawmaking, in view of enriching that individual countries are guided towards unifying norms which speak to our common Africanness and other respects such as human dignity and values as espoused by the African Charter on Human and People's Rights. Honourable members, I think that broadly, we are all on the same wavelength on prison oversight. And this despite some divergence, which will be reconciled through further stakeholder consultations. I believe that the very essence of the rule of law carries us in the same direction on prison legislation. Parliaments, as a custodian of the rule of law and the doctrine of separation of powers, recognizes the importance of judicial decisions and abides by it. Honorable members, when judicial decisions provide for custodial sentences with imprisonment, no defender of the rule of law will certainly agree that the term of imprisonment, which is a hardship in itself, must be accompanied by other extrajudicial punishments imposed arbitrarily by those who are not in judicial offices. Once, honorable member, a judicial decision is taken, the punishment must be meted out with transparency and without additional hardships which are not foreseen by the courts of law. Honorable members, we believe that the model law on prison oversight seeks to achieve the reasonable ideal that only the judicial punishment imposed is implemented, rather than other punishments such as lack of food, lack of health facilities, torture, and inhuman and degrading treatment, which no court of law adjudicated upon. Honorable members, this subservience of judicial decisions under the spirit of the separation of powers must not be confused with the view that Parliament seeks to influence judicial decisions under the model law. That is not true. And in fact, it is the exact opposite, which is true. Parliaments, through its oversight functions, will accordingly ensure that the judicial decisions concerning carceral punishments are met without other hardships commonly suffered by prisoners in the SADC region. That is why, or some of the reasons why we're investing in this process, for the SADC region to embrace modernity and harmonize its norms. There is indeed a need for prison oversight by parliaments to be intensified. This is to say, honorable members, that the current arrangement with visits by magistrates or appointed committees are insufficient. But the point is that the adequacy or sufficiency of existing arrangements should be a theme under parliamentary scrutiny. Honorable members, democracy spearheaded by a functioning parliament must not have shadows which are beyond the sight of parliamentarians. The model law seeks to oust the shadows and bring prison oversight into the spotlight. It is a tool to promote democracy and the acceptance of the rule of law. The rule of law is not reserved for free citizens, but also for citizens with a disability whose rights are mitigated by the state through the carceral system. At the end of the day, we are here to promote parliamentarism through the modern lawmaking process. Honorable members, I'm confident that by using your various contributions as scaffolds, the legal drafters will aptly proceed with a robust model law provision, which further empowers the role of parliaments vis-à-vis prison oversight. The model law is not one law. We are going to come up with the omnibus model law that allows us to tackle the complexities that we have outlined. With these words, honorable members, I encourage you to be safe, keep safe, and ensure that you return your parliaments intact. I thank you for your kind attention and wish to thank all facilitators, all staff, our interpreters, our translators, and all those who have made this session a success. Thank you, honorable members, and give yourselves a round of applause. I declare the meeting closed, honorable members. You may.
Thank you.
You may accordingly. Please stay in your hotels, honorable members. Please keep yourselves safe. Unless you have security, you go into the right vehicle, which is no, please don't leave the hotel. I beg you, honorable members. Thank you.